case has reached the Supreme Court, and there are some certain directions for medianship. It's called, like they said. So, is it possible to keep this case on hold for some time?
Then why your man will not take up? So simply, it was stated that it was stated by learned party in person, which is that 84.
84 serial number.
We will simply adjourn it to March.
Your Honor, thank you, Your Honor.
7th March.
Thank you, Your Honor.
Contempt matters?
Making correct statement or not? Party in person. You don't. He's saying something is pending for Supreme Court. Correct or not?
Number one, so contempt matters. Mr. Sundaresh.
Complaint in this case.
One is dismissed, delayed, dismissed. It's kept for orders. Dismissed. Yes, next. After how many years you are filing contempt petition? 4 years.
So number two,
May I please?
Mallikarjun G.
These complainant are the ex-employees, the company in liquidation in this case. The accused settled the arrears of salary. The company came into liquidation in 1/4/2004. The office liquidated settled the arrears of
It's returnable on
Please.
March, 11th March.
3,
Same,
4,
up to 6.
6.
Up to 6. Same directions.
Up to 6.
Please,
Notice same.
please.
This number 7, Mr. Srinivas V. Number 7,
Fourth accused, my lord. So the
Srinivas.
fourth accused, my lord, he died about 20 days back. I will file necessary memo to that effect by next day.
Who died?
Raju, Kalappa, what are the fourth accused here?
Fourth respondent. It was stated that the respondent who has died, therefore steps are required to be taken, stand over to, full stop, stand over to 13th March.
Please.
Number 8, Mr. Srinivas K. Number 8, Mr. Srinivas K.
Keep that. Pass over.
Number 9,
Lordship, I appear for the
Ivina J.
complainant.
Kamat.
The complainant had applied for construction of on his property, Your Lordship. The accused had given a direction, had given an intimation that he needs to relinquish a part of his land to get the sanction for construction. We had approached this Honorable High Court. The order is at
12th March.
Your Lordship, an earlier date may be given because he's unable to construct on his own property. Any earlier date may be given, Your Lordship.
6th February.
Yes.
6th February.
Obliged.
Number 10, Mr. Amit M. Hegde.
The PDA had to execute the sale deed within 3 months' time as
Page.
Lord,
Page.
page, my lord.
Which order?
My lord, order of I bought I've not got the original file, my lord.
No, you bring the file. Arguing without file is not permitted. When you come with the file, we'll take up. We don't entertain a lawyer which is without file.
Please.
Yes. It's a basic courtesy to the court
Please.
to have a file in your hand.
Please.
Yes. 8th of January.
Number 11, Mr. Sundaresh HC.
But appear for complaint in this case. Direction is to conceal my representation for a period, within a period of 3 months from the date of certified copy of the order. So far.
Notice returnable on
Short date.
13th March. 11.
So PAL matters. Number 12, Mr. Murali Krishna Brahmanandam, party in person.
Pass over.
Number 13,
May I appearing for a petition.
Mr. Keshav Bhatt.
But the respondent trust was granted a land, my lord, for the formation of a park actually. But at a concessional rate. But having taken the land, my lord, for the construction of a park for a temple,
But they have built a commercial complex as a convention center. We made a request, my lord, to cancel the grant. There are other illegalities also, my lord. Annexure A is the sanction order. Annexure A, my lord, page 24. Last sentence there. Ananda Seva Sita Trust at rupees 40 lakhs only per acre by the department for the purpose of formation of a park and its maintenance.
Page 24.
Pardon?
Which page the order is? Page
Page, my lord, I am sorry, 24, my lord.
24.
Ink page 24.
So that is some order.
But this is the sanction order, my lord, granted. Can I just, with reference to the above subject, the government has perused your proposal cited at reference. I am directed to inform you that the government has accorded sanction for granting 10.5 guntas of land in government land, pairing number 45 of Kadirenahalli village, Uttarahalli, Hubli, Bangalore, South Taluk, in favor of Shri Ananda Seva, Ananda Tirtha Seva Trust for at rupees 40 lakhs per acre by the department for the formation of park and its maintenance subject to the conditions of the land grant rules. Then sale certificate is annexure B.
It is granted to the trust.
Trust for the purpose of making a park.
No. Trust is building a commercial complex.
Now they have built a commercial complex and renting it out.
And
Renting it out for
it is already constructed.
I haven't said it.
Commercial complex is already constructed.
Yes.
Then what can be done?
But the total grant is
Demolition.
illegal, my lord, on the face of it. Only now we have realized. And my lord,
What is returnable on 54? You say February 23rd.
My lord, the prayer is only to consider the representation.
Even otherwise it is constructed.
This number 14 to Ventation.
In this case, my lord, install the statue of the Basveshwara at the entrance of the office of the second respondent deputy commissioner, where in the public place, my lord. The state government has approved the sanction of 15 lakhs rupees to install the statue, my lord. But in the place of the district Ranga Mandira. But in second respondent is violating the order, my lord. They're installing the district commissioner office in front of the district commissioner office, my lord. And my lord, kindly see the page number 69, my lord.
That is annexure F.
My lord,
Page
annexure.
F. That is your challenge.
Annexure A is the pass of the order, my lord. The page number 33, my lord. Annexure A. The transaction copy in page number
That is
15,
annexure F. This court's order.
104, my lord. 104.
What is that order?
The Supreme Court order, my lord.
Supreme Court order.
Yes, my lord. The Apex Court order, my lord. 105, my lord. Last paragraph. As in the entry measure, we direct the henceforth no authorized construction shall be carried out and permitted in the name of temple, church, and Gurudwara it is, on public street, public park, or other public place it is, in respect to the unauthorized construction of religious nature which has already taken place. The state government and the union territories shall review the same on the case to case basis and taken appropriate steps to as possibilities.
Now, what do you want?
Now they are going to inaugurating the status, my lord. The kindly grant the
In
entry
the name
mark.
of temple, church, mosque, or Gurudwara. Here, what is the construction?
And one more High Court judgment also is there, my lord. In one month.
Here, what is the construction?
The Basveshwara statue, madam.
Statue.
Statue.
How?
Deputy Commissioner in front of
Whose statue?
Basveshwara statue, madam. Basveshwara,
Who is Vasveswara?
Basvanna, madam.
Some leader
I have
is a
produced
god,
I have produced the photos
is
copies.
a god, deity, leader, common man, big man, small man. Who is Vasveswara? I don't. You have to enlighten me. Saint and
But-
poet. They tell. You approach the authority. Called learned advocate Mr. So and so for the petitioner and learned additional government. Learned additional advocate, additional government advocate. Nilofarat for the respondents upon service of copy of the petition in advance. The petition, who claims to be a public spirited person, has filed this public interest petition. Where the grievance espoused is about the installation of statue of Sri Basavanna, saint and poet. It is the case that the statue is erected in the front of district Ranga Mundira, which is within the corridor of the district administration Bhavan, Namrad Nagar. It is awarded that the district in charge minister did the goodly puja for the installation of statute and responded to deputy commissioners without following the terms of the approval. Permitted putting up of the statute of Sri Basavanna at the entrance, which is towards the western side of the deputy commissioner's office. It is the case that the statue ought to have been put in the front of district Ranga Mandir. Petitioner paragraph has relied on order of the Supreme Court. Where is the order of Supreme Court? Page 104. Order of the Supreme Court. Dated 25th. March. No, dated Order of Supreme Court in Union of India versus State of Gujarat. Dated 29 September 2009. Integrated AIR online 2009 SC 593. Submitted the court as required that the authorities should monitor the unauthorized erection of church, mosque, temple, gurudwara, temple, church, mosque, gurudwara, etc. on the public streets and public parks as well as at other public places. And the unauthorized construction of religious nature. They have to be dealt with in accordance with law. It is the case that though the petitioner gave notice to the respondents to stop the work of constitutional statute, since it is not exceeded to, since it is not paid heed to, now the present petition is filed. The prayer made therein is to direct the respondent 4, respondent 3 and 4, who are the Assistant Director, Kannada and Cultural Department, and Chamarajanagar City Municipal Corporation respectively, to strictly follow the order passed by the Apex Court. Upper order में so and so state of Gujarat, which was SLP number 8519 of 2006. He said it on 18/1/30. And further, and follow the order, aforesaid order, the Supreme Court. Full stop. The court deems it fit to dispose of in the facts and circumstances case, and having regard to the nature of grievance raised, the court finds it appropriate to require the petitioner to first approach with further representation to the competent authority of the respondents and air the grievance. Full stop. The press representation may be filed within 10 days, which shall be considered by the authorities on its merits and in accordance with law. And the decision will be intimated to the petitioner within 6 weeks thereafter. The present petition is disposed of accordingly. So next.
Cell number 15. To Nataraj Sharma.
Sorry for the petitioner's counsel. The lordships were to see the prayers. In all fairness, I should admit that we are restricting our prayer only to the extent of challenge to the 31st August 2023 government order, insofar as it prescribes, or rather, in our opinion, dilutes the educational requirements for the post of Pollution Control Board chairman. This subject matter has been a matter of litigation before this honorable court, and several orders have been passed. In fact, I just wanted to produce those orders, but I won't point it out. In fact, the coordinate bench, my lords, when the 19th June 2020 guidelines were issued.
Now we directed reinstatement to chair.
Yes, but that's over. In fact, his term is over, my lords. Now they've issued a circular calling for fresh applications.
Yeah.
In 2020, my lords, guidelines were issued specifying certain educational qualifications. This honorable court, my lords, passed a series of orders, directing the government to tweak it. Finally, they approved it. Now, what the government does is, it dilutes those educational qualifications, which is what we're aggrieved by. And eventually, my lords, the Honorable Supreme Court and this Honorable Court have repeatedly said we should have a chairman of the highest academic as well as... I'm sorry, my lord.
Qualification must be in the act itself.
Yes, not in the act. Could I request my lords to kindly see first page 37, page 35 at 37. To give a background, my lords, the Act under Section 4.2 prescribes certain qualifications. The Honorable Supreme Court, my lords, in Techi Tagi Tara's case, had issued various directions to issue guidelines. These guidelines were issued pursuant to the Honorable Supreme Court's directions. Kindly see clause 3 at page 37. Page change agide. Illa 2020. Kindly see page 37, my lords. My lords has it. Clause 3. No person shall be eligible. Page 48.
Page 40.
48. Page 48.
48.
Page 48 at page 50. My lords will see at page 48 that this is issued pursuant to the Honorable Supreme Court's directions. At clause 3, my lords, what the government says is, my lords will note this is 19/6/2020. My lords may kindly see, no person shall be eligible for being considered for nomination as chairman unless he or she Kindly mark this, my lords. Possesses a master's degree in environment science, kindly mark environment science, or a master's degree in environment engineering, or an equivalent degree, and so on. So these were the guidelines, my lords, that were issued in 19th of June 2020. These guidelines, my lords, were a subject matter of challenge in WP number 9526. Here, copy. I pass on this compilation.
My lord, on Friday or Saturday, if I remember right, my lord, the committee has been constituted under the chairmanship of the chief secretary. My lord, whereby this qualification, my lord, has been included. If my lord could have this on Wednesday, my lord, I'll make a submission.
Very well. I'm grateful. If it is being reconsidered, my grievance would be worked out. Now, can I just point out some orders of this on board, just for the sake of
Praying
completeness?
writ of quo and
Not go on. No one's been appointed. We're challenging the guidelines insofar as it dilutes the qualifications and it's opposed to this honorable court's directions. That's all we're seeking.
nobody.
No one's been appointed. No one's been appointed.
So Wednesday, 2:30.
Yes, my
Very
lord.
well. Great.
My lord, the name of Mr. Mahesh Chaudhary may be shown for respondent number 5, my lord.
Extend out to 20, today is what?
16th,
Extend out to 18th of
18.
obliged, my lord.
to be listed at 2:30. At the request of learned additional government advocate Srimati Neelafar Akbar, who appears and wants to take instructions, please stop. Name of learned advocate Mahesh Chaudhary, appearing for the State Pollution Control Board, shall be indicated on the board on the next date. Copy may be given to him also.
Very well. We'll serve a copy, Mr. Mahesh.
Obliged, my lord.
Obliged.
Still number 16. Rajesh Kumar.
Not appearing for the petition. Lords, in the last, this is a matter where we're discussing the solid waste management, my lords. Solid waste management, my lords, in the city of Bangalore. Lords, on the last occasion, the council for BBMP had submitted that he would be filing the status report.
It's already filed, my lords.
My lords, I have not been served a copy.
I can serve it now, but it was already served to them before. I can serve a copy on them again. Serve a copy of it.
Where is your status report? So
Look,
this will have to be heard little.
It was filed on 13th December, my lords.
13 December.
Yes, my lords. It's a report, my lords. There were certain concerns which was raised by the petitioners in the joint meeting which was held, my lords.
10th December it is there. 10th December.
My lords, it's filed on 13th December, my lords.
That is not here also. You put the house in order. Same. Same. But the file on. Give copy to.
I've not
Lords,
been-
I have,
I don't have a copy.
Find out.
I'll serve a copy, my lords.
We'll take up after vacation.
My lords?
After vacation.
Yes, my lords.
15th February. Learned advocate, Mr.
Yes. Photocopy and give it. Just take it on. Yes.
Before it is stated by learned advocate BBMP, the status report is filed. Our copy is not. Our copy is not. How it appears that the copy is not given to learned counsel for the petition. Such copy shall be.
Copy served, my lords.
Within 1 week. The status post of send out to 15th February. It is observed that For the next date, the respondent, BBMC shall file report also about the steps taken in respect of collection, transportation, and process. Domestic waste generators, bulk waste generators, biomedical waste generators, by detailing the steps taken separately in the above regard.
Fifteen two, my lord.
Let's, the next date, 15.
15.
Mr. K. S. Raghuram.
Seventeen.
Give me this pen. Give me this open folder separately. Fifteenth February. This will come for orders. Saturday. 18th February. This will be. This may heard and reserved for judgment.
Reserved.
Complied.
18, 19, 20 are urgent. Seal number 21. Number 21, the Som Sundar Rao, sir, writ appeal.
18th.
Mr. Som Sundar Rao, seal number 21.
Yeah. What is the punishment?
My lord, the order of reference as well as the award was set aside and the punishment was confirmed, my lord.
You are for respondent.
But both order of reference as well as award has been set aside and punishment has been confirmed, my lord. 19 years of delay.
Where is the counsel?
I am representing R2, my lord. R1 is the contesting respondent as well as.
Who is the counsel for a petition? Keep for the time being pass over.
This is number 22, state appeal.
Appealing for the appellant, my lord. So the delay of 15 days in filing the appeal, my lord, the matter relates to grant of land to ex-serviceman, my lord. At the original instance, my lord, 10 acres of land was granted, my lord, which was found to be a forest land. Therefore, a revised order has been passed. Now, my lord, in pursuant to the orders, my lord, 4 acres of land have been granted in a different village, my lord. Originally, my lord, 10 acres of land was granted.
He was
That was-
entitled to 10 acres originally.
Originally, 10 acres was granted. That was found to be a forest land, my lord. But
That right continued to remain. for
no, my
10
lord,
acres.
under the land grant rule, my lord, rule 7, the competence of the deputy commissioner is only up to a maximum of 2 hectares of
That
land.
is
my lord.
subsequent, not at the time when this grant was cancelled.
No, my lord, it was there, my lord. It was amended in 2000. It was there, my lord. The order, like the original grant order was a mistake, my lord.
When
10
the
acres
grant
he was
was
not
cancelled?
entitled.
Grant was cancelled when?
No, my lord, what has happened now, my lord? The new allotment is in another village, my lord. There is a disparity in the value also, my lord. Rule 7 is extracted in the appeal memo, my lord. Page 13 it is extracted.
Where is your reply was filed in the main proceeding?
The reply was filed.
Your objections were filed in the main.
Filed, my lord.
Where is that? Is there on record? Yes, page 190.
Yes.
Now this Karnataka land grant rules came into force when?
Rule 7, my lord. Rule 7, my lord. The competency of the deputy commissioner
When,
is to grant about 2 hectares of land.
when it came into force?
Lord, that was in 1969.
69.
Please, my lord. Thereafter amended in 2024, where the extent was
So then
reduced.
none
my
of the earlier proceeding you would raise this point.
lord, the previous
There are
round.
several round of litigation.
My lord, there's one more aspect, my lord. Even the disparity in the value, my lord. Earlier, it was a part of the forest land, and my
Now
lord.
you first clear this aspect.
Please, my lord.
In none of the earlier round of petitions you raised this point, that only 4 acres was liable to be granted instead of 10.
That was not taken, my lord, earlier.
What is your stand in the main petition? Where is your reply? Reply was filed in the petition?
Reply was filed, my lord. Page number 163 is the reply, my lord. Statement of objection
163.
was filed.
63. You're dismissed.
Lordship may kindly consider this, my lord. There is no, one is that, my lord, the land that has now been allotted, my lord, is 4 acres of land in a better place, my lord. Earlier it was rejected on the ground that it forms part of the forest land, my lord. In terms of the value, my lord, this 4 acres of land has more value, my lord. In fact, it is Rampura village, my lord, which is in a better place.
The right to get 10 acres is crystallized when?
No, my lord, the earlier thing, my lord, it was.
And how many petitions were filed? 3 at least. And
My lord,
in
there's no
none
availability
take
of
that
this extent of land, my lord, which is free from the forest area, my lord. That is also identifying a land is a challenge, my lord. And there are several other applications which are also pending, my lord. These are the 2 considerations, my lord. In
we'll
terms
deal
of
with
the value of the original granted land and this land, my lord, that
dismissed. Next.
Still number 23,
Here on.
so Murugesh V. Charity.
But this is the matter where publication,
The delay of 11 days.
yes,
Notice returnable on January 22.
my lord, may I also make a submission? Only respondent 1 and 2, my lord, rest are all, my lord, who are the judicial officers now, they're sitting here. We have no prayer against them. And already in a similar writ appeal, may I just pass on this order? This, your lordships have already granted an interim order. And my lord, there is a cost imposed against the newspaper publication. And that, my lord, the State Legal Services Authority, my lord, brought it to the notice of the learned single judge that cost has not been paid. In fact, there was no prayer as against us. And my lord, that prayer is also, we were directed to remove that article. That, my lord, was removed way before the order was passed. So he said it has become infructuous. In fact, that matter also is listed today at, I think, serial number 142.
Let them come 23rd, which was 22nd January.
Lord, I'm seeking for an, though, my lord, I understand that there is a delay,
there
but
is a
seeking for
delay.
an interim order, my lord. Your lordships have already granted, my lord, where the Registrar General has filed, and the same order, my lord, again, the same direction. Para 63, my lord, if your lordship sees, page 56 of the learned single judge's order.
Why you are super?
No, Lord, we wouldn't have troubled your lordships, my lord. What has happened is the State Legal Services Authority, my lord, they have written a letter, my lord, that the amount has not been deposited. My lord, what has happened is there was no prayer as against us. The only prayer was to delete that publication. That even prior to the passing of the order by this honorable court, we had already deleted. So, my lord, the learned single judge holds that it has become infructuous. My lord, all the prayers, my lord, have not been granted. And what the learned single judge does, my lord, is to hold an inquiry as to who leaked the report. So, my lord, and then but imposes, my lord, a cost on us to be paid to the State Legal Services Authority. In fact, my lord, the learned district judge, as he then was, he had filed a suit for damages. My lord, that suit was withdrawn during pendency.
So notice to.
Lord, only 1 and 2, my lord. If your lordship sees the response, we are nothing against anybody else. Only because that they had to be made because they were parties before the learned single judge. In fact, the other matter where your lordships are granted interim orders listed today
What
at serial
about,
number 142.
What about 7-2?
No, my lord, may not be. My lord. We have not, my lord, claimed any.
Petition cost. So what about this 8-2, 13? Who are the press reporter and
Lord, nothing as against them. 8-2 out. Lord, not required. editorial.
You already granted stay in that other one.
Yes, my lord. That's why, my lord, that is also listed today. Interim order in this, my lord, though I know, my lord, there is a delay, but if your lordships, my lord, are on, because if the matter comes up before the learned single judge, my lord, then my lord, your lordships have, my lord, with regard to the inquiry, but the cost, my lord, then will have to be
But that
10
order-
lakhs has been awarded.
Same order is under challenge in that petition, in the appeal.
Yes, my lord. But
It
they
is-
have challenged it to the extent of an inquiry being held to see as to who has leaked the report.
True.
So that is, my lord, your lordship's order is that, my lord. If para 4 of your lordship's order.
But you have said directions in paragraph 63 of the judgment
Yes, my lord.
and state.
So that includes this also, but my lord, may I only seek, my lord, that in this also, my lord, to hold an inquiry, my lord, what your lordships have said is that when the entire subject matter is before this, the direction paragraph number 63 of the judgment, whereby the learned single judge has requested the High Court to hold an inquiry could not be permitted to be acted upon. So, my lord, only to that extent it becomes, but then the second part, my lord, where we have been directed. In fact, my lord, it's not even as damages, my lord, it was the prayer, my lord, if your lordship sees what, my lord, the learned single judge, my lord, at para 29, my lord, he says the prayer, if your lordship sees page 29, my lord, may kindly turn to in page 29, internal page 18. That is the prayer where, my lord, the learned single judge says it is complied. So nothing survives. So there's no further. However, the learned single judge, my lord, goes beyond it and says, my lord, before parting, this is what I. And my lord, if after the inquiry, my lord, if.
Which are the directions against you?
Beg your pardon?
Which are the directions against you?
My lord, if your lordship sees the only prayer, the direction, my lord, is in para 56 and 63, my lord. If your lordship sees para 62, my lord.
60?
Para 62 at page 55. Page 55 of the learned single judge's order.
So this number 13 is the appellant hearing?
Lord, appellant, my lord, is the Indian Express. The respondent, respondent 13.
Don't pay the cost for the time being. We'll give a short notice. Notice returnable on 13th of January.
9th of January.
9th of January.
Please, oblige. My lords have notice only to 1 and 2.
No, only to 1 and 2. Notice to respond 1 and 2 only. Returnable on 9th January. The appeal shall be listed along with that other appeal.
That is 677 of 2024.
77 of 2020.
In fact, it's listed today.
So both will go on 9.
Please.
In which is that 677? 142 to stand over to same date. Same date.
Oblige.
So number 24. PV Patil.
With your lordships kindly, my lords, this is an appeal preferred by the Karnataka Industrial Area Development Board. My lords, at the outset, I would state that there's a delay of 140 days, my lords.
Notice written on 3rd March, 4th March.
Appearing for the caveator respondent number 1, my lord.
On that they will consider. Let us.
Please, deeply obliged.
Please.
This is number 25.
Same
Yes.
orders.
State
5th
appeal.
March. Notice written number. 26 also same.
Number
order.
26.
5th March. Now 27.
So number 27, Mr. Shivanand DS.
Waiting for response 2 and 3 in this matter, my lords.
Serial number 27, 28, 116 and 120, my lord. All the cases which are listed today are arising out of a common order passed by the rather single judge, my lord. Respondent has also filed a writ petition. So his writ petitions are allowed, our writ petitions are dismissed, my lord. So against that also writ appeal number 1660/2024 is also filed. That is not listed today. Therefore, all the matters are required to be heard. That's why, my lord.
May I make
The connected appeal number so and so is not listed along with the caps and appeals. all including so and so.
But there
so and
is
so shall be
some
discharged.
urgency in the matter, my lords.
On-
Lords, there is some urgency in this matter, my lords. Their interim order is operating against us.
Then after vacation.
Lords, the
Not-
difficulty is this, my lords. We are having difficulties because of the interim orders which was granted in the matter which was posted before the vacation bench. Subsequently, there are about 10 or 12 writ appeals filed. There are another 40, 50 writ petitions which are filed based on the my lords interim orders which has been passed by this honorable court. There is an extreme urgency because the properties with which we are concerned, my lords, is a series of transactions which has taken place by virtue of which it's come to us. They filed a suit for injunction, it is dismissed. Now, even now, my lords, we are facing the difficulty because of the interim orders, notwithstanding the dismissal of the suit and an
Immediately on reopen,
reopening day, my lords. I'm sorry, in the reopening week, my lords,
9th.
please.
Interim,
Of course.
my lord, in 27, my lord, though last time, my lord, it was mentioned, my lord, the interim order in 28 may also be granted in 27, my lord, because interim order is only against appellant in that case, my lord. That is the same interim.
Today, no further order.
Please, please.
20. Interim order may be.
Number commercial appeals, number 29. Mr.
Petitioners,
Prasad,
I for the petition, Karnataka Rural Development Appeal, Your Honor.
Delay.
Delay was 24th. Delay, yes, please. No.
Delay. Notice written on 28th February.
Already I served the copy to the cavator. I don't know last.
Today, no time.
One marship.
Whole company
Maybe
appeal shall go
stay,
beyond.
maybe it's an urgency for that. Your
The
Honor.
company appeal will go beyond that.
Lordship.
Some dates. Not today, not to be taken.
Allah, and some. One submission.
34 few days.
Stay may
Number-
be granted for.
But it
Arbitration
can be granted when there is a delay. That's very clear.
At last
The
occasion is
reason
appeal.
some order is passed.
Please.
Never, appeal is never registered. Yes, till the delay is gone down. Yes, next.
Please.
number 34, the arbitration matters. Shanmant Reddy ji,
This is what? This is also
Appearing for the appellants, my lord.
any urgency?
My lord, there is an apprehension of the execution, my lord, to be filed.
Take
by-
time in execution. 13th December, January.
My lord, notice has not been issued. Notice has not been issued.
Notice written on 13th January.
Obliged, my lord.
Number 35, Mr. Anirudh Anand.
My lord, in this at serial number 35.4, my lord, the government has filed an application, my lord, for direction. My lord could have this at 2:30, my lord. The learned additional advocate general, Mr. Rubin, will be appearing.
This matter, my lord, in fact, 10A2B has been challenged, and this on court has already been pleased to allow the matter. And my lord, order has been challenged before the Honorable Supreme Court. The matter is pending consideration before the state itself has filed an appeal. It may be called after vacation.
My lord, there's some emergency, my lord.
There is no urgency, in fact. The matter is pending before the Honorable Supreme Court, wherein in fact they have to make this application. It is their own appeal, state appeal.
Go after vacation. 7th February.
Much
Obliged.
Great.
Second respondent in first matter.
For the petitioner in the first matter, 36.1. Yeah.
So this is that matter?
Please.
After vacation.
Yes.
Reopen. 12th February. 12th February. Next.
For the petition this matter, my lord. My lord, on the last occasion, your notice was directed respondent number 1 to 5 to file the statement of objection, my lord. But other than respondent number 5, respondent number 1 to 4 has not yet filed the objections. And respondent number 5 has filed served the copy without the annexures, my lord. Respondent number 5 has served the copy without the annexures, my lord.
What can we do?
My lord, serial number 37 appear for respondent, my lords. This one number 5, my lords. May I request for a week's adjournment, my lords?
So you're seeking ground on the ground that number 5 is given copy without what?
Without annexures, my lord, respondent number
Without
5.
annexes. So you are seeking time on the.
I'll provide with the copy of the annex.
That 6 time on the ground that respondent 5 is not given annexes.
Annexures. They have served the copy of the objection without annexures.
Whatever I speak ground right. You want time on that ground?
My lord, the other respondent have not yet filed the statement of objections, my lord.
What do you want? Time. Ultimately time. 11 advocate. So 6 time. Extend over to March 11 as requested.
38, Mr. Ravindra Gajanan Kolle.
My lord, and in this, I pray for some time to file my
It
statement.
can go to March, 7th March.
Number 39, Mr. S.Y. Shivalli. 39, Mr. S.Y. Shivalli.
Let it go to
My lord, this may be called on 6th of January. My lord, similar matters, my lord has posted on
6th of
Friday.
Jan.
Number 40.
lords.
1 PM.
40 and 41 minutes. Can it
Lords,
be?
may I
immediately
request for
after-
password?
Immediately after vacation minutes, this
Beyond
matter.
vacation.
Yes, immediately after vacation.
Lords heard this matter regarding closure, man.
17th of January.
My lords,
Please, minutes, may I make a request, minutes 40 and 41 goes together. It's a common order. Minutes, I had the benefit of interim order minutes. The lordship may kindly extend the interim order, which is, please, obligations.
Number 42, so state appeal. Number 42.
There's a delay of 77 days, my lord, in filing the appeal. There's a delay of 77 days in filing the appeal, my lord.
Notice returnable on
Caveat, my lord.
March.
Notice to
13th.
R2, my lord.
13th March. Notice is already there. What is the delay of
Delay of 77 days, my lord.
who appears?
From Maruti.
Wait then. Keep back.
Number 43. State appeal.
43, my lord, the additional advocate general, Mr. Ruben will appear, my lord. Lordship may pass over the matter, my lord.
What is it about? Urgent, yes, otherwise.
Provision of
Yeah.
2011 rules, provision of 2011 rules, my lord, which provides for promotion to the post of.
Promotion can wait. 29th February.
My lord,
29th of February.
Lord, there is some urgency. This is, my lord, 2011 rules, my lord, a provision has been struck down, holding that it is unconstitutional, my lord. Since 2011, my lord, till 2023, the rules were operated.
May not be possible. 16th February.
Lord, a shorter date, my lord, because my promotions have been withheld, my lord, because of the some
18th February.
first week of January, my lord.
Not possible.
Number 44. Number 44. Mr. T.P. Mutana.
Respondent.
Number 44. T.P. Mutana.
Delay. Delay on 19 days. So everybody is appearing, all respondents are. appearing?
I appear for the respondent.
All,
Only one respondent.
only one respondent.
Yes.
IA number. This is 44. IA number 1 of this application, heard learned advisor respective parties. This application is filed seeking condonation of delay of 19 days, which has taken place in filing the appeal. It is stated that after the order was passed, the issue of filing appeal was placed before the competent authority. The time was consumed in processing the matter. Full stop. The appellant is a bank, an impersonal body. Full stop. The delay is attributable to administrative process and decision-making process. Sufficient causes paragraph, sufficient cause is made out from the evidence in the supporting affidavit. Delay of 19 days deserves to be condoned, it is condoned, application is allowed. So appeal shall go to, appeal may be listed on 21st February.
Number 45. Mr. Jayasima KP. Mr. Jayasima KP, 45.
Petitioner, my lordship.
We are petitioners, revenue site holders, and using the synopsis to the.
What is the matter?
The matter is for the lapse on procedure of respondents.
Argue.
Yes.
What is it about? No, we'll not set synopsis unless you argue.
Yes,
I do not continue.
There is these petitioners are revenue site holders since 1997, and they are holding a kata also, Your Honor, and regularly paying tax and living. They are in possession of the lands. There was a JP Nagar 8-stage layout preliminary notification in 1988, Your Honor. Thereafterwards, the said notification was quashed by the High Court, Honorable High Court order WP number 4810 of 1990. And there was it has passed the order to consider the grounds of the have not sanctioned the schedule. Government has not sanctioned the plan or scheduled property, as therefore it was the final notification was quashed. Similarly, again in 1999, there was a notification, and in that notification, there was it was considering that there is a sanction, and they have issued a notification for the scheduled properties. But the scheduled property was only 3 survey numbers, Your Honor, and notified Katedas and Anvodas were not being given any notice. And in 1999, there was a status quo order also by the in the writ petition number 2286 of 1999. In that, after that, there was one more writ petition. Series of writ petitions have been filed, and in 2001, the Honorable High Court has directed the BDA. If BDA has required the land in question, there is no escape for them to pass the award, conclude acquisition proceedings, and pay the compensation for the land. But till date, there is no compensation has been paid to the respected landowners, Your Honor. And again, in 2002, there was one more writ petition filed by the revenue owners on particular survey number 36/1 in WP 2719 of 2002, Your Honor. Still, there was in 2002, there was an interim order not to dispose the petitioners from their respective property. Again, on 19/4/2002, there was a directions to the BDA to consider the representation and form accordingly within a span time of 3 months, Your Honor. Thereafterwards, the respective in 2005, again, my lord, in 2005, the land was in question was not even, the position was not taken. And there was the respondent has handed over the part of the land notified to private developers to certain extent, to the extent of 55 acres, Your Honor. And they have developed the land. Again, in 2006, 17/3/2007, there was a notification to withdraw the acquisition of the land in question, Your Honor. So in 2007, they have withdrawn the whatever the survey number which has been notified in 1999 year on 5/4/1999, there was a notification to acquire. After that, in 2007, they have withdrawn the notification for only 2 survey numbers and leaving 1 survey number wherein these petitioners are in possession. In 2011, again, the land bearing same survey number, it was challenged in WP 27/188 of 2011, and the petition was allowed in favor of the petitioners, and it was already because it was already a converted land, and there were the petitioners have occupied and they were living there. Hence, the implementation of scheme was not able to be, possession was not able to take place. And there was a lapse of acquisition proceedings and and lot of denotification in favor of developers and private parties for scheme implementation was done. Henceforth, the writ petition was allowed in 2011, Your Honor. And these petitioners have till date been in occupation and regularly paying tax and are in the possession, Your Honor. As BDA respondent has withdrawn the notification in 2007 and only not considering only 1 survey number, that is where the petitioners are there. I pray for the, I have challenged the same in the writ petition before the Honorable High Court, in WP 99/35 of 2023, Your Honor. And it has not been regularizing, nor there is any implementation of scheme in this particular area where the petitioners are residing. And there is no new any developments have been taken place. Just considering that BDA notification in 99, the respondent is just lapsed because of lapse of procedure. It has been abandoned, Your Honor, that particular area. And petitioners have been deprived of getting the BBMP, whatever the they have to get from the society for as a Samaritan, as a citizen of that particular area, though they are paying tax and other facilities, which has been deprived, Your Honor. Sewage and street lightings, roads have not been constructed in that particular area.
My lord, the petitioners claims, my lord, they have purchased the sites in the 2000 and 1997 after the completion of the acquisition proceedings, my lord.
2000 or 88?
They, no, 2000, first petition purchased in the year 2000, my 26/4/2000, and others purchased in the 1997. Other petitioner purchased in the 1997. First petitioner in 2000.
2000.
There, my lord, the acquisition was completed in the year 1988 is the preliminary notification. 99 is the final notification. My lord. Award was passed on 2001. Award was also deposited in the civil court. My lord.
We allowed her to be dismissed.
Pardon?
We allowed her to be dismissed. What do you suggest?
No, my lord, because there is a.
You are saying emphatically that
It should be dismissed, because my lord, the Supreme Court, this honorable court said, my lord, that subsequent purchaser have no right to challenge even the lapsing of.
Sorry, madam. You have no right.
My lord, one
subsequent purchaser, 88 acquisition.
No, my lord. 1999, 5499 was the notification for only for 3 particular survey numbers. And it has been denotified in 2007, Your Honor. So when considering this honorable court's order in 481.
Give your synopsis, we'll deal with it.
Yes, my lord.
Dismissed.
And it has been covered by judgment in 2011, Your Honor. They are just giving the
What happened in 1999?
Nine-
Then your purchase is 1997,
yes, my lord.
97. So that is even earlier.
No, my lord, the preliminary notification was,
Yes, final not. Dismissed, sorry. Give the appearance, yes, next.
Number 46, A.V. Gangadharappa.
Delay of 73 days.
I filed the application seeking for condonation of delay.
Who appears?
The
I'm for respondent number 2, my lord.
Mr. Venugopal.
2, 5, and 6.
Any other respondent remain?
2, 5, and 6 I appear.
Mr. Venugopal.
If all are appearing, we can count down the delay.
My lord, the others have to appear, my lord. They have been served.
They are served.
They have been served.
All are. Our learned advocate, Mr. So-and-so, the applicant IN number, it is IN number 1 of 24. Still number 46. Our learned advocate, Mr. Ganga, you are Mr. Gangadharappa. AV for the applicant. Learned additional government, Harish for the.
Or 2, 5, and 6, my lord.
For respondent,
Respondent number 2, 5, and 6.
2, 2, 5, and 6. Also, the rest of the respondent is out, but none appears. Also, this is an application seeking condonation of delay of 73 days, which has taken place in preparing the appeal. Also, the affidavit accompanying the interim application spells out the reasons for cases of crime. It was stated that the where is that application? Very modern. It is stated that after deliverance of the judgment and order by learned single judge, learned advocate for the appellant forwarded certified copy along with the entire record of the petition. With an opinion that the order is required to be challenged before the higher forum. It is stated that at that time, it was a administrator who was governing the Panchayat, and there was no elected body. Therefore, the proposal for filing of the appeal was forwarded to state government for further processing. The final approval paragraph was given, which resulted into, when final approval was given, which resulted into delay of 73 days. It was urged that the consumption of time is an administrative process to stop. The reason supplied is palatable. Since the appellant is a Panchayat of the municipality and a body of local self-government, which was ruled by the administrator at the relevant time, time was consumed in decision-making process before a decision could be reached to prefer the appeal. No element of culpability or negligence could be attributed to any officer. In the circumstances paragraph, sufficient cause to condone the delay of 73 days is made out, delay is condoned, application. The writ appeal may be listed for hearing on March 5th March. Same order in 46.1. IA number of 24.
This number 47. So state appeal.
My lords, a date may be fixed for this matter, my lords, for final hearing.
Is a delay again?
Delay is of 47 days.
Delay of 47. You are for appellant?
I'm for the respondent.
It's a state appeal.
State's appeal.
State appeal. So delay may be condoned.
Yes.
IA number 1 of 24. We say heard learned additional government advocate, Mr. Harish, for the appellant. Only one respondent?
Please, Mala.
And learned advocate, Ms. Priyanka. What is your name, Priyanka?
Priyanka.
Priyanka Yavagal. For the only respondent.
Only respondent.
Only respondent.
Please.
This application is filed, praying to condone the delay of 47 days, which has taken place in filing of the appeal. So the accompanying affidavit spells out the reasons for passage of time leading to the delay to the aforesaid extent. The appellant is a state. Therefore, in the decision making, in the hierarchy of the authorities, consumption of time is inbuilt and inherent. Also, it could not be said that there is an element of culpability or negligence on part of any of the officer or the respondents. Delay of 47 days deserves to be condoned as sufficient cause is made out. Whereas delay is condoned, application is allowed. Appeal may be listed for admission hearing on 28th February.
My lords, an early date can be given,
Early
my
date may
lords.
be given, my lord, because the provisions have been struck down, my lord, where they have to, the requirement of obtaining permission from the government to make appointment.
28th January.
Lords, on the opening of the vacation, my lords, the reason being, the urgency is this, my lords, the academic year has already begun. The impugned order has already been executed, my lords, partially executed.
Execute.
Please, my lords, it's implemented partially.
Lord, the
Permission till the year 2022 has already been granted, my lords.
What is the order?
No, no.
Which is
Lord,
executed?
the Rule 17 of 2006 rules, my lord, which requires obtaining of prior permission, my lord, to fill up the vacancies was struck down, my lord. As a result of which, my lord, the institutions would inform the government and go ahead with the appointments, my lord. See, the earlier condition was that they have to obtain the permission of the government to make the appointments to fill up the vacancies.
So you're appointed already.
Well, there is a notification, but that has not been complied with.
No, request
Requires some-
lordship to have it immediately after vacation, my lord.
Please, my lords. And if it could be at
Nearly-
2:30, my lords,
He is saying that you are already acted upon the order, implemented the order.
please, my lord.
No, my lord,
My lords,
the-
if it could be at 2:30, my lords, there's grave urgency. There's grave urgency in the matter, my lords. The matter has somehow not been able to reach on.
We'll keep it early, but not graver.
Please, my lord.
16th of January.
Case number 48, Mr. Sunil Kumar S.
Appearing for the appellant minutes. It's senior is not well minutes, kindly any other date my fixed minutes. Senior is not well minutes. Senior is not well minutes, so kindly any other date.
Why not?
Is suffering from viral fever minutes. Viral fever minutes.
When he will get well?
Minutes.
When he will get well?
Minutes as soon as possible minutes.
As soon as matter is
Any
possible.
short date minutes.
All right. March 10th March. Any urgency?
Minutes. Kindly after, have it after the vacation minutes.
After week, 10th March is after week.
Yes.
Number 49, Mr. Ramesh Chandra.
I appear for the appellant, my lord. Kindly pass over, my lord. I have to file the one document, my lord. Pass over, my lord.
Pass over to which date? 17th February.
My lord, immediately after vacation, my lord.
This is immediately after.
In January, my lord. Otherwise, they will dispossess the premises, my lord.
Next.
Number 50, Patil Dayanand.
appellants.
I appear for R3, my lord.
By annexure B at page 29, municipality had conducted a public auction in which I was my brother was the highest bidder.
Brother.
Appellant's brother was the highest bidder. His bid was accepted for an amount of 3,150. He was put in possession of the property, and it appears the auction was reported to the deputy commissioner. This is in December 1977. Then at annexure C, there is another resolution of which, according to the petitioner appellant, he was not put on notice. Deputy Commissioner sent a communication saying he has cancelled the page 31. Page 31. The resolution reads like this, my lord. The resolution dated 6/12/77 to sell the coconut garden so and so is nullified as per the order dated 27/7/1978 in official memorandum so and so by the deputy commissioner. Since the town municipal council has power as per section 72(2) of the act to sell the property through auction in case the value is less than 5,000, the decision of the municipal
counsel subject to examine and decide the application submitted by the appellant on so and so, requesting to accept the auction proceedings. Decision. Following decision is taken after reading and understanding the application of the applicant and provisions of section 72(2) of the Act. It is a garden land comprising of coconut plantation, and the same is not suitable for any site or development work of the TMC, and also situated away from the village and humid region. Auction publication is issued in the newspaper and auctioned in public, and the highest bidder, that is applicant, is permitted to enjoy the property in accordance with law. As per the provisions of the aforesaid Act, has powers to transfer this property to the highest bidder. Despite the letter, correspondent is carried out with the Deputy Commissioner and the order is issued. Hence, it was accepted and resolved that the matter shall be brought to the notice of the Deputy Commissioner and to request to issue orders by recognizing the power of the Town Municipal Council available under section 72, and that the said property may be transferred through a registered document since the final bidder is in possession and enjoyment of the property, and he has paid the entire amount to the Town Municipal Council. This all happened in 1977. They refer to certain communication of 1977 or 78, where Deputy Commissioner is supposed to have cancelled that resolution. I applied for copy of that order, any such order at Annexure F, my lord. Municipality has issued, Deputy Commissioner's office has issued. They don't have any such record of the order. That is at page 41.
You have not produced the copy of the petition?
Please.
You have produced the copy of the writ petition?
Yes, my lord.
Where is it? Page.
It starts at, writ petition starts at page 17, my lord. 17. Kindly go to page 41. Neither the municipality nor the Deputy Commissioner's office has the so-called copy of the resolution or the order of the Deputy Commissioner cancelling the resolution.
But you are coming after how many years? 3 decades?
No, I'm not asking for the relief. I will only point out this, madam. Your Lordship may kindly see, after all this, I wrote to the municipality. You have passed a resolution saying you have the power. You have auctioned. Please execute the sale deed. Municipality said there was an earlier order by the Deputy Commissioner, therefore we are not in a position to execute.
That is 77.
That is
That is
at 49, 21/8/2017.
2017, yes.
17. If the learned single judge felt that I have approached the writ court belatedly, the highest that could have been done was, in view of the belated approaching, writ petition is dismissed. I would have accepted that order. I am in possession of a property. Learned single judge records a finding at page 15, second para. The petitioner has not taken any action from the year 1979 until the month of August 2017. And the court is of considered view that even if the petitioner has any right, it stands completely extinguished by petitioner's own inaction for a period of 3 decades. I am in possession of a property for 3 decades. I will work out my rights in the civil court. Recording of this finding was not necessary for dismissing my petition if I had approached belated.
Which finding?
The finding that you have all the rights are lost.
Naturally, after 30 years.
After 30 years, I get a right of prescription. I am in possession of a property, admittedly. Municipality says I am in possession. I purchased the property in a public auction. I paid the amount in 1977. I had sought for a relief for a direction to execute registered sale deed. If the court is to deny that on the ground of delay, I have no objection.
Who appeals?
I'm for R3, my lord, for the municipality. My lord, in this particular case, my lord, the actual auction was done in the year 1977, my lord. The auction purchaser, the present petitioner is auction purchaser's brother, my lord. My lord, this auction was in the year 6/12/1977, my lord. Subsequently, yes, he is paid 3,100 rupees because he was the highest bidder at that particular point of time for auction. Subsequently, they also sent this for the approval, my lord. And the after approval, that was their auction was cancelled in the year 1979, 28/2/1979. It was subsequently cancelled, my lord. And after this cancellation, in 2000,
Cancelled on which date?
my lord, it was cancelled on 28/2/1979. Cancelled by R2 on 1978.
So what is this order dated 21/8/17?
No, 20.
28/2/79,
28,
not the cancellation, my lord.
Not cancelled.
It was
Your lordship may kindly see page
page
31.
number 31, my lord.
Cancellation 1979.
No, my lord,
Yes.
it's not so. It refers to an order of the deputy commissioner dated 27/7/1978,
Which date?
page 31. Subject number 6, from there, my lord. It is supposed to have been cancelled. That resolution is cancelled, not auction sale. Then I applied for copy of that order, any such order. Even now, municipality is also not having the copy. An endorsement is given that such an order or record is not available. And in page 31 resolution, municipality says, yes, we have auctioned, we want to execute the sale deed. They are not repudiating the transaction. Page 32 may kindly be seen. Decision. The following decision is taken after reading and understanding the application of the applicant and the provisions of section 72 of the Act. It is a garden land comprising coconut plantation, and the same is not suitable for any site or development works of the town municipal council, and also situated away from the village and humid region. Auction publication is issued in the newspaper, auctioned in public, and the highest bidder is permitted to enjoy the property in accordance with law. As per the provisions of the aforesaid Act, town municipal council has power to transfer this property to the highest bidder. Despite that, letter correspondence is carried out with the deputy commissioner and the order is issued. Hence, it was accepted and resolved that said matter shall be brought to the notice of the deputy commissioner and to request to issue the orders by recognizing the powers of the municipal council under section 72(2), and that the said property may be transferred through registered document. Since the final bidder is in possession and enjoyment of the property, he has paid the entire amount to the town municipal council and has spent huge money. I would even go to the extent of saying, my lord, If I had approached the writ court belatedly, in fact, at again ಒಂದ್ ಸ್ವಲ್ಪ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ. ಅಂದ್ರೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀನಿ.
So you are appearing for whom?
My lord, the possession of this property is also with the government only, my lord. It is not with the petitioner, my lord. Still the possession is with the government only. The honorable court may see the page number
You are appearing
26.
for number 3
Yes, my lord. Okay.
and who is number 2? You are for 2.
For respondent number 1 and 2, my lord.
1 and 2. So for orders on the 18th.
SB Mukanappa.
Have done after vacation, my lord. After vacation, my lord.
After vacation, which is number, serial number 51, at the request of learned go the appellants tend over to. There is a delay, will issue notice.
24 days delay. 24 days is delay.
Anybody appears?
My lord, the notice has been served, but not appeared.
Not appeared. Okay. Then it will go to, when do you want? 12th February?
Much.
12th February as requested.
Number 52. Sir, Master RK GMM Mas Swamiji party in person.
My lords.
This is
My
same
lords.
matter that super time scale.
Yes, ma'am.
With this, no time after vacation.
My lord, please, my lord.
There is no time now, Mr.
My
We will
lord,
not be able
there
to
is urgency, please, my lord.
see
There is
immediately.
urgency, please, my lord.
Immediately on reopening.
My lord, on the earlier date, it is said, it will be finally heard, my lord. Please, my lord.
So reopening.
20 minutes.
13th of January.
My lord,
13th of January.
my lord, please, my lord.
Today not possible. We don't have time now since last.
Tomorrow, or-
No.
please, my lord, please.
Earliest date we are giving. Yes. next.
My lord, 18 or 19 of this month, please, my lord. 18 or 19th of this month, please, my lord. There is urgency, my lord.
That's not.
My lord,
53.
at least the adverse you may be expunged and it may be ordered for reconsider. Please, my lord. There is Supreme Court order, my lord.
After vacation.
After January 2nd, my lord. At 2:30,
Second January,
6th, my lord.
6th January,
Oh, please, my lord,
15th
please,
January.
please, my lord. It may be finally ordered, my lord.
We'll do
Please
that.
give the relief, my lord. Please, my lord.
Number 53. Mr. Samit, yes.
There's a delay of about 152 days. The delay because my lords, I had also preferred a review in the matter. And the review came to be dismissed only in August, my lords. And subsequently, we have preferred this appeal.
Pardon? Delay.
Delay of 152 days.
Who appeared?
In the state, and we have
Report
also
number one.
served the board, my lords, water supply board.
Body served, nobody appeared.
No, nobody is appearing, my lords.
I
We have
prepared
already
for
served
respondent
them.
number 1, my lord.
Also, my
Already
lords, we have
report.
served the standing council on 22/11/2024.
Name is not shown. Name of the council not shown.
They've served both the board as well as the panel advocate. No one has appeared.
Name of the council is not shown, my lord, in the
Name
cost
is
list.
not shown. Name of.
Not shown in the cost list.
You
my lord.
inform the board advocate, we will condone the delay. Inform the advocate for the board whose name is not
Very well. Pass over, my lords.
pass over, not pass, day after.
Day after tomorrow. I'm grateful, my lords.
18.
54. Urgent. Number 55. Number 55.
My lord,
Fifty-five.
for the appellant.
We're not taking up after vacation. It's commercial appeals. Choose your date. 11th February.
11th February. Our photo. The suit is stayed, my lord. My lord, is it possible to give us a date in January? Man?
And if that can be given. 17th January.
This is number 56.
Lord, this is a challenge to the provisions of National Biodiversity Act. Lord, I filed an IA to delete the cabinet secretary. Lord, he is an unnecessary party. R2, Ministry of Environmental and Forest is the right ministry.
6 time, my lord. 6 time, my lord. Need to
No, my lord,
application,
this request
my lord.
has been made, my lord, every single day. And my lord, my application is pending since 2013. No objections are filed. Lord, why should the cabinet secretary be made a party? And that too with Rashtrapati Bhavan address. I have filed an IA, my lord, in 2013.
IA4.
Lord, I had to delete that 5th respondent because 2nd respondent, Ministry of Environment and Forest, is the right ministry. It is already there. So 5th respondent is unnecessary. Every time, my lord, some new counsel comes and says we need some time. And the main matter, my lord, nobody is ready to argue. The constitutional validity of National Biodiversity Act is challenged. Anyway, my lord, today that matter may be taken up some other day. Today, my lord, my IA may be allowed.
So you want to delete Union of India?
No, the Union of India would be represented by R2.
Then if it is.
Or rather, Lordship may say, R2 would be represented by Secretary, Ministry of Environment and Forest.
That can be, we see, but what is the difficulty if number 5 is there?
Not Cabinet Secretary, my lord, he is not the right party. The right party would be the Secretary, Ministry of Environment and Forest.
That can be done.
That can be done, madam. With a liberty, my lord. I need to. This is a challenge to the constitutional validity of a section, my lord. Hence, Ministry of Law and Justice needs to be brought on record, my lord. I'll file necessary application to that.
Anyway, Law and Justice, he can bring on record separately, not necessary.
With a
Ministry of
liberty,
Environment and Forest is the right one.
Today only we are deleting the cabinet secretary.
Please, my lord.
On the ground that the number 2 will take care of the interest.
Yes.
Please, my lord.
So I will pass you.
I am grateful.
So IA is disposed.
IA number.
IA number?
1 of 2013.
It will be disposed of.
Please, my lord. I am grateful.
Silent. Now, where is it? Our learned advocate, Mr. Our learned additional solicitor. Where is the tally? Arvind Kamath for the applicant. Learned advocate, Mr. You are Mr.
Chandan, my lord, for shooting.
Original appellant, original petitioner. What is the petition for?
The provisions of the National Biodiversity Act has been challenged on the ground that they are unconstitutional.
We will dictate the order. Find out the IA. IA is there. We will dictate the order.
I am grateful. Public.
Number 58, Mr. Govardhan S.
For the petitioner, ma'am. Any date may be fixed after vacation, ma'am.
My lords, request for a short accommodation, my lords.
Serial number
58, my lords.
58. This PIL.
Yes, my lords.
What is that?
It's filed against,
My lord,
yes,
at the time of filing of the establishment of the golf
golf
course,
course, my lords.
public road has been encroached.
We have filed an application seeking for injunction, my lord. We'll present the arguments on the next day. Petition is not maintainable, my lords. I'll make the submissions on the day.
So this order says that without encroaching the public property to make khata as per the plan approved.
Please. Lord, that is what, my lord, indirectly they have allowed them to encroach the lands, my lord.
My
My
lords,
lord,
this is
they have,
purely a,
admittedly, they have encroached the lands. It is on record. They have admitted that they have encroached the lands, my lord.
my lords.
What prevented them to remove the obstructions, my lord? It is on the village roads, my lord.
My
The
friend here
villagers
is
are
making
prevented to.
My friend here is making false submissions, my lord.
No, my lord,
Actually,
it
this
is not a, it is on record.
filed
Where-
to
What is
ventilate
there to
private grievances.
falsely represent?
Any order is operated?
My lord?
My lords,
Office objections are filed?
we have filed our objections, my lord.
Where are they? On which
It is
date?
filed on,
12/11/24.
I'm for respondent number 4, my lord.
IA.
For both IA and main petition, we have filed our objections. My lords, will present our arguments on the next date, my lords. Request for a short accommodation. We've engaged the senior counsel, my lords.
Who wants time? You want time?
Yes, my lords. After vacation, it may be listed, my lords. We'll present our arguments.
At the request of learned advocate, Ms. So-and-so with the respondent, stand over to. February 14th.
My lords,
14th February.
much obliged.
My lord, any date in January? Humble request, my lord.
Not possible.
Much obliged.
Very grateful.
Number 59,
Recall
Omkar
application
KB.
seeking to recall the peremptory order, my lord, for non-compliance of his objections, my lord. With 2 weeks are granted, my lord.
Of 24.
His
This
objections.
application is heard learned parties. Is the application filed. Delay is also there.
48 days, my lord.
IA order in IA 3 of 24 with IA 4 of 24. Then first subtitle order in IA 4 of 24. Present application is filed for condonation of delay of 78 days, which has occurred in filing the restoration application. The accompanying affidavit spells out the good reasons to make out a sufficient cause. Additionally, full stop. The delay deserves to be condoned in order to enable the applicant to contest the case on merits. Application is allowed, delay is condoned, application is allowed. Then order on 3 of 24. The present application is filed for with a prayer to restore the spirit of it. The writ appeal was dismissed on the ground of non-removal of office.
My lord,
On the ground of
non-removal of
non-removal of
defects.
office objection. In the affidavit it is stated that since the appellant had undergone an eye surgery in both the eyes, swift action could not be taken even as the time was stipulated for removal of a hold. It is stated that once the appellant recovered from the eye surgery, the steps were taken instructing the advocate to comply with the office objections. The reason is acceptable. Full stop. It is right that the appellant is permitted to contest the case on merits. In that view, appeal is restored to its original files with all subsisting orders on condition that whatever office objections are left out from being removed shall be removed within 3 weeks from today. The application is accordingly allowed. Next.
60 urgent, number 61. So complaints in contempt matters. Mr. Ravi Shankar K. Number 61.
My lord, I appear for the respond number 1 in this matter, my lord.
I was appearing for respondent number 2. By order dated 19th March, I was asked to get impleaded. The counsel for the petitioner submitted that I was a necessary party and I was party to the writ proceedings. I was not a party to the writ proceedings. However, we have filed an affidavit also stating that we cannot absorb him because he was above 48 and our guideline provides that we should take only below 40. So, my lords, I may be deleted as an area of party in this matter. We are not party before the writ court, nowhere. And the copy has already been served.
Who is appearing for complaint?
Mr. Ravi Shankar.
Let it go.
My lord, I have filed my reply affidavit reporting the complaints of the order passed by this honorable court, my lord.
61. So what is this about?
Unless there was a direction given to consider his representation. He was an ex-employee of STCL. There were certain employees who were absorbed in various departments of Ministry of Industries and Commerce. So Coffee Board comes under Ministry of Industries and Commerce. So direction was to consider his representation within 3 months. That has been considered is what the counsel for the unit
Doesn't survive.
doesn't survive for consideration.
Yes, madam. Is it correct?
My lord,
Your voice is not reaching. He is also for respondent.
Respondent number 1, he has filed a
my
complaint.
lord, I filed my reply affidavit, my lord.
Keep back. Let the complainant come. Pass over.
Number 62. Shubha Bar Mishra.
I'm appearing for the complainant, my lord.
Here the respondent. Senior not well, kindly grant 1 week time.
After record. It was a time was prayed for on the ground that the senior counsel is not available, 10 or 17.
My lords, we've given an NOC, my lords, our names may be different. We've given NOC, my lords, our names may be different.
Names may be?
The name Yashu Mishra for the complainant may be different.
We have filed our NOC Wakalat today in the counter, my lord.
What is the request?
Lords, Yeshomishra appearing to the complainant names. The name may be deleted.
Delete and will do on the next date, next.
So number 63.
I am the complainant in this case. I am the complainant in this. Issue number 2, my lord, the violation of the order passed by this honorable single judge, my lord, the annexure, page number 30, my lord. Annexure B, page number 30, my lord. The respondent number 4, which has been served has remained unrepresented, is directed to reinstate the petition of forfeit. Respondent number 4 is also directed to draw.
Not reinstated or not?
My lord, he was reinstated, but my lord, the accused number 4, my lord, has not paid the arrear salary and as well as the 25,000 rupees cost imposed by the honorable court, my lord.
It's not the private trust, ma'am.
The-
Institution, my lords.
My lord, the institution is my lord, accused number 2, but in earlier, my lord, the before honorable single judge is not appeared. That's why my lord imposed the cost. Today, in my lord, this before this honorable court, my lord, in contempt matter is also not been appeared before this court, my lord.
Nobody appeared.
Nobody appeared, my lord.
Srinath
Srinath P for accused number 2.
appearing. So pass over.
This is for 64. To P N Anja Reddy. 64.
Yes, we have filed our compliance affidavit. Direction was to consider the representation.
Where is that page?
That's the affidavit, my lords. We have filed it on 24th. And page 2 of the affidavit, my lords. Lordship will get it at page, paragraph 3 and 4, my lords. The details. And the R1 is the endorsement. R2, page 17 is the endorsement, my lords. R1 is the government proceedings, my lords.
Nobody is there, but after that. None present for this. Complainant, learned lady from government. Advocate, Ms. Pramodin, Mr. said the order is complied with. Our since the present petition is not present, stand over to 6th of March.
Number 65. Mr. Adi Narayanappa. Number 65.
Even here, we have filed the compliance affidavit.
Same order, 6th of March.
So number 66. Mr. Murthy K.
Yes, for the respondent, my lord, I have filed the complaints affidavit. The direction is to pay the family pension. That has been paid, my lord. I have produced the statement.
Yes, my lord. It is
Both the
complaint,
learned paid,
complaint, my lord.
both the learned are ready to submit that the order, directions under the, brought under the contempt proceeding are complied with, nothing survives in the petition, it is disposed of as not surviving. Yes.
Number 67.
I
Mr.
appear to
Raghunath
complain
MD.
in my lords. I'm appearing on behalf of the respondents, my lord.
My lord,
Lords, on the
this-
previous occasion,
My lords were pleased
You
to
move this on.
hear the matter. In fact, certain documents were produced by the complainant, my lords, showcasing that the orders passed by the Honorable Family Court were not complied with by the accused.
the calls, video calls were made, WhatsApp voice calls were made, which were unanswered, my lords, till date. And the few calls which were answered, my lords,
Where is the order?
please, my lords, this is at ink page number 32 at Annexure D. The last paragraph, my lords. The petitioner shall have access to the child by name of Shivans Yadav, aged about 4 years, who is in custody of the respondent.
File
He can
additional-
meet the child.
File the reply,
My lord, we have filed the reply, my lord.
additional reply. Respondent to file additional reply.
My lord,
Send out.
this one
They
submission, my
make a
lord.
humble submission, my
Wa-
lords.
Only one respectful
Apologies for
submission, my lord.
intervening. Only thing is, let them be directed, my lords, until the further reply has been filed by the accused, that they will let the petitioner or the complainant to talk to the child, my
On
lords.
that day.
My lord, if I may make one submission, my lord, if I may make one respectful submission, my lord. This very same order that my learned friend referred to, my lord, if my lords could kindly lay hands on that. my
On
lord.
next day, we'll see.
At least a direction, my lords,
Di-
if I
ma-
may see.
No direction may be passed, my lord. We will obey the orders passed by the honorable trial court, my lord.
We're only requiring you to file additional. Next,
At least in the first week of January, my lords.
first week of Jan,
A date may be fixed, my lords.
13.
My lords, at least earlier to that, if I may seek my lord's indulgence in granting an earlier date, my lords.
Even earlier is given.
At least 6th or the 7th, my lords. 6th or 7th of January.
That's not possible. Next.
Number 68, non-filing replace in contempt matter, 68.
For complaint. I filed a writ petition in, it was disposed, matter was
I'm
disposed.
to file my
in
wakalat
direct-
in this matter, my lords. I'm to file my wakalat for the accused in this matter. Short date maybe.
Prashant needs for the respondent.
And government is not a party in this.
Sixth,
Government is not a party in this, madam.
sixth time. Send out to 3rd March.
Number 69,
Hearing for the
Mr.
respondent, my lord, compliance has been
Shant
done.
Kumar Nagaya. 69,
I'd like to file my compliance, my lord. It's for Podi, the rest.
Nobody is there.
No, my lord.
21st annual. Learned additional government rules, Miss Shweta Krishnappa files compliance every, which is taken on record. 10 or 21st annual.
Taken on record.
number 70, Mr. Rajshekar S.
Not yet complied with the directions. Page 23 is the order, my lords. Internal page 15, page 23, division bench of this honorable court, third line, my lords. Out of the said amount of rupees 40 lakhs, a sum of 10 lakhs shall be paid by the respondent to the appellant within a period of 3 months.
Who appears?
The third represented, my lords.
Venkatesh Sumareddy.
They have entered appearance.
Somebody is appearing?
Yes.
Pass over.
Please.
Number 71, Mr. Chandrasekhar GM.
This also has been complied, my lord. It's with regard to payment of salary. Compliance report is dated 28/5/24.
You complied with.
Please.
Live. It is already filed.
Yes, my lord, it's dated 28/5/24. Filed on 4th June.
You transferred to somebody at some other. Representative is transferred. salary for the period as sought for, and it has been transferred, so it is complied.
Please, my lord, this is with,
Transferred to which department? Treasury Department,
it's not with regard to transfer, my lord, it's with regard to
account to
salary.
the complainant.
Salary. I have produced the,
So this will dispose of in the second
Please.
round.
please,
Keep back.
48,000 has been transferred.
We will, even if it doesn't come in this follow. In the second court, 71.
Much obliged.
This is number 72.
Let us see, the order may be dictated.
Yes.
This is 71.
71.
The directions in this contempt petition which are sought to be complied with are dated 11th, are in the order dated 11th April 23, passed by learned single judge, disposing of the petition. Whereby disposal 3 and 7 were directed to consider the representations dated 15/11/22. Representations, comma, all dated 15/11/22. And to be produced as an Excel, not all, two representations dated 15/11/22 produced by Annexer B and Annexer C respectively, within stipulated time. In the compliance affidavit paragraph, as was pointed out by learned additional government advocate Srimati Veta Krishnappa, it is stated that
Correct.
after the aforesaid order of learned single judge, appropriate action was initiated for considering the representation. It is further stated that the salary for the period as paid for in the representation has been transferred in the account of the complainant. The documentary proof evidence is the transfer of the amount. Also, in the above view, nothing survives in the contempt proceedings. They are disposed of as not surviving. But you do call out in the second round.
Much obliged.
This is number 72.
Appearing for the complaint, my lord, for want of instructions, kindly have it after vacation, my lord.
After vacation,
Yes, my
at the request of learned, why?
My lord,
For want of some instructions, my lord.
I am filing a memo along with intimation letter issued to the complaint, my lord.
You paid the amount on,
No, my lord.
not,
My lord. Intimation letter to issue to the complaint for production of original documents, my lord, not yet come before the authority, my lord.
You make it.
for what documents now you need?
Not, what has happened
Original
is,
documents.
After court's order, no documents.
No.
After the court passes the order to pay rupees 2 crores 94 lakhs 67,137, you can't ask any document.
not, we have asked for those original documents to be submitted so that we can release the compensation to him.
No document
And-
now. The following are the directions issued by learned single judge in order dated 30th November 22, while allowing the writ petition number 4069/22, and quote these 2 and 3, page 13 over. Full stop. A clear direction is given by learned single judge to the respondents. You're not given any document.
I'm proxy counsel, my lord. Kindly have it after vacation.
Yes. Because you yourself stated for the court that you will appear and submit the document.
And I have proxy counsel appearing in the matter, my lord. Hence.
Order was passed on 23/8/24. The parties have to act in accordance with the observations as committed by them. Full stop. In the said orders, the complainant has stated that he would appear with his authority and submit the necessary documents before the payment could be released. Paragraph, when the contempt petition comes up for consideration today, pursuant to the aforesaid order, learned advocate Mr. So-and-so prays for time, send over to, not in hurry or to get the compensation, 18th of March. As request.
Number 73, with Chandraya.
Here for the complaint, my lord.
Appearing for the accused lords, we have complied with the order logic. Same, I am filing the affidavit regarding the same.
May I submit one sentence, my lord? Till 11:30 was waiting in the office, my lord. Nobody has come. He was not taken on duty even at 11:30, my lord. It may be posted to some other day. If they have taken, I will get it dismissed. If they have not taken it, I will file affidavit. But they have obtained the signature on 13th. With my consent only, he has put the signature. In the beginning, they did not put the date for this. Thereafter, when I put the date, they have put the signature.
You are reinstated or not?
Yes.
I have
sir.
not
Yes,
yet
sir.
reinstated, but a document has been, my signature has been obtained for the document.
We do not know. Are you go and join the duty?
Oh my lord, since morning, since 9 o'clock till 11:30, I was waiting before the office. This is, I called before entering the court.
When you will go, tomorrow you will go again.
Today also goes, tomorrow also goes, my lord. He is in
And
the.
now when will you go?
Huh?
There is a dispute about.
No, my client since morning is waiting at this office of the accused. He was not taken on duty on 13th. On 13th, they have obtained my signature to the document.
Are you ready to instate or no? Reinstate or?
Reinstated.
Then
lords.
give a application for joining duty.
Signature is also on.
Yes, my lord, I am ready with this, but there was nobody to take me on.
Same.
On the card.
Same.
Chicken.
13, 12,
13th, 12, 2024.
13, 12.
Page number 3, lords.
You are reinstated. What?
Yes, lord.
My lord, by document they have reinstated, but actually they have not taken me on duty. It may be posted after vacation. I file my affidavit for the compliance.
You go again to me.
Yeah, oh, I do go, my lord.
What is the, what work you are doing?
I am working as a matey as well as waterman.
Waterman.
Waterman for the service of water. Matey means there is a bungalow, brothers bungalow. I was looking after it. They have removed it. I appealed. Thereafter, I came in writ.
Order of law in a single judge contains direction of reinstatement of the petitioner, complainant, as waterman committee.
Yes, ma'am.
Full stop. While the contempt is alleged about the non-compliance of the said direction, today the contempt petition comes up for consideration. The compliance affidavit is filed by the respondent, Panchayat Development Officer, along with which recruitment order dated 12/12/24 is produced, in which it is stated that pursuant to the order of the court, the petitioner complainant is permitted to continue to hold the post of IB Meti cum waterman, and is ordered accordingly. Full stop. The said recruitment order admittedly bears signature of the petitioner complainant. Full stop. However, in course of the hearing, a grievance was voiced by learned advocate for the petitioner, Mr. So-and-so, that though the petitioner is waiting at the premises of at the place of the respondent, he is not actually permitted to join the duty. Full stop. The petitioner shall again approach respondent number 2 pursuant to the aforesaid order dated 12/12/24, and the respondent shall take him duty and issue an order taking him on duty to be produced before the court on the next day, send over to day after tomorrow, 19th, to be listed at 2:30. He
Yes,
will
Lord.
come and you issue the duty joining order, that's all,
Yes, Lords.
right?
Much.
Obliged.
Number 74. Mr. Venkatesh TS.
Appearing for the complaints, my lords. My lords, the matter pertaining to an old pension scheme and new pension scheme, my lords. The single bench had considered my contentions and gave me liberty to file my representations, my lords, which is not considered, my lords.
My lords, for accused number 4, University has preferred writ appeal, my lords, which is at serial number 111. Against the same order of learned single judge. So it may kindly be put up after vacation.
There is a delay of 300 odd days, my lords, in that appeal.
What rate appeal against this order? All right, when rate appeal will be taken up for hearing?
Writ appeal is listed today, my lords, today.
Today,
At serial number
Serial
111.
111, it's listed, my lords.
then we'll take up at 2:30.
That's anytime after vacation.
Right? 9th of January,
Obliged, my lord.
to be listed with readable numbers.
My lords, serial number 74,
It is
75,
requested by learned advocate Ms. Swan.
serial number 74, 75, and 94, same band matters, my lord, arising from the same.
475.
594,
94, all will go together, common order.
please, my lords.
Plus 111.
Say not 9th, the 17th January,
Obliged, my lords.
17 January.
also not 17th January, 16th January.
Obliged.
Yes. Number 76.
I pay for complaint.
Rakesh, can you?
Learned single judge order is at page number 15, my lord. Learned single judge has directed the accused to consider my representation.
This case, I may be permitted to file now. Either. I'm for the accused. I'm permitted to file my affidavit.
Where do you stand? Complied with?
Your Lordship, it is not the compliance, Your Lordship, the allegation against the,
Directed to address the grievance.
yes, I have
The
addressed the grievance. Your
representation
Lordship.
dated 30th/5.
Yes,
Orders are passed on representation.
yeah, yes,
And there's one more direction.
What is that direction?
For 3 weeks, they shall not take any coercive steps again.
may I take it? Your Lordship, the petitioner herein was a borrower. In fact, the complainant whom he has addressed as accused, he was not at all at the branch, but he has transferred from the branch on 16/5/2022. He was not at all the branch manager at the point of time. The allegation of the complainant is that there was an interim order against the bank to consider the representation. In fact, Your Lordship, I'll submit, Your Lordship,
We want to order and representation. Where is that order?
Your Lordship,
Page number 67,
67.
67, interim order.
No, their compliance.
compliance, Your Lordship.
They are not served on them,
Yes,
Not served.
not served.
Serve first time, then to give to the court.
yes,
Do it. No use of arguing without serving the
I
court.
permitted him to.
Just received.
Where is your decision representation?
Your Lordship. On 19/7, Your Lordship,
Page.
page number 63.
Page?
63, Your Lordship. R3, R13. May make some submission, Your Lordship.
The complainant had filed the complainant had availed the loan and committed default, and he has not paid even one installment. And we have filed the OA before the debt recovery tribunal. And we have also issued a seizure notice on 2/5/2023-24. The bank has entrusted the work to the Crystal Recovery Agency, Mangalore, to seize the vehicle. Since he has not produced the vehicle for inspection, nor he has given the key, nor he has produced any documents to the bank. So bank has entrusted the account became NPA. Thereafter, bank has entrusted the seizure agency of the bank to seize the vehicle. Fellowship, he has filed the writ petition before this Honorable Court. By the order dated 27/6/2024, this Honorable Court has passed the interim order. On 26/6/2077, panel advocate addressed a mail dated 27/6/2024, communicating that writ petition was dismissed. I have produced the communication sent by an advocate to state that the writ petition has been dismissed. Thereafter, Your Lordship, since there was no interim order, the bank has proceeded to seize the vehicle, and they have sold they have seized the vehicle. The communication, may take Your Lordship to the communication sent by an advocate at page number 61, Your Lordship, Annex A1, R1, R11. This is to inform that you are captioned the matter listed on 27/6/2024 before the Honorable High Court of Karnataka, before the Court number 14. When we have appeared on their behalf, the advocate for the petitioner submitted that bank had proceeded by filing the original application before DOT, even though settlement talks are taking place. We have informed the court that there is no settlement in the matter, and that petitioner is making false submission.
Counsel, this Canara Bank doesn't know how to respond to the court's order. You go on writing the communications, decide the representation. Our manager should be here on the next day. Decide in clear terms, yes or no. That's the only thing you are supposed to do. Not to write letters and go on communicating with the petitioner. Decide yes or no.
Your Lordship,
There is yes or no. You have to decide the representation, that's all.
Yes, Your Lordship.
Not go on communicating with the petitioner.
Their representation was considered by the bank, Your Lordship.
Where is the decision? Tell us. Give a line, show a line that this is a decision.
Actually,
Any of your communication.
Page number 13, 63, Your Lordship.
This
63.
long correspondent is no
Yes.
answer. Yes. Page
Page 63, Your Lordship.
63.
Yeah.
Where is that?
Your Lordship, sorry, page 65, Your Lordship. With reference to above, we have sanctioned loan of so and so on today. On purchase, after sanctions the loan, you are not paid the regular installment of account slipped to NPA on 1/5/2023. After repeated follow-up, you have not paid only 75. Further, you have not submitted RC book or second set of the key or refraud at the bank. The bank has already initiated recovery and legal action by filing DRT case for recovery of your liability of 26.88 lakhs to the bank. Further, we have also seized the vehicle. At this juncture, bank cannot stop the DRT action, cannot extend the time to clear the dues. We are also informing you that all the full outstanding amount to be paid immediately. Else, bank will therefore proceed with the recovery action. Your Lordship, he had filed the representation after our filing the OA. He has not paid even 1 rupee, Your Lordship.
Two directions.
This can be said to a decision, though not a very good.
There are two directions, my lord, as per learned single judge's order.
So that other direction will remain.
No, other
File a petition challenging this.
challenge.
The direction of not taking coercive step for 3 months, 3 weeks.
They already taken my vehicle, already seized my vehicle, just
When?
3 days after passing of this order.
When?
On my list of dates may kindly be seen, my lord.
This is what I want to submit, Your Lordship. This
2024 itself, they have seized. 26/6/2024, the order was passed, my lord. Just after 3 days, they have seized. They are well aware about this order, my lord. Respond bank also was represented by an advocate for the learned single judge.
That's what I read.
Read again. It is made clear that till respondent passes approved order.
Yes.
Takes approved decision on the representation. Interim order till
3 weeks, for 3 weeks. This just 3 days, within 3 days, they have seized my vehicle.
So till it is decided, not beyond 3 weeks.
Yes, they are not yet decided. They are decided on 19/7, according to
When
them.
the possession of the vehicle is taken,
29/6/2024.
29/6.
Yes.
Now the page 65, which is being shown is on which page? Page. Which is the date you are saying?
29/6, madam. As per their compliance affidavit, which they filed today, in that page number 63, my lord, 19/7/2024 is the letter, according to them. 19/7/2024, according to them, they replied to my
No, not that.
notice dated
Next.
35.
65.
65.
Yes.
If it's 65 also, it is
65 is
28.
28/8.
28/8. But this vehicle has been seized on 29/6. So they could not have seized till they reply.
29/6.
Yes. That is absolutely not in dispute. And I'm told that they already auctioned the auctioned my vehicle, my lord.
That is what we said. Exactly. This is, the stay was to operate during the consideration of the representation.
Yes, my
Supposed to
representative is
be
not
done in 3
considered.
weeks.
Yes,
And this is, your vehicle is after the decision. After the decision.
That's what I'm saying. My representation not been considered. My representation was considered on 28/8. So till that time, they could not have seized
Where
my
is the
vehicle.
vehicle seizure? order?
Vehicle season 29/6. Just 3 days after the order.
Correct. Issued on 28.
My list of dates may kindly be seen, my lord. Page number 2. List of dates. Page number 2, my list.
So that you have to demonstrate from the record that vehicle was seized before 28/8/24.
Admittedly, it was seized on 29/6/2024.
Your Lordship, may I take your Lordship to page number 60, Your Lordship? The bank was represented by an advocate and he has addressed a letter as per Annexure R10, Your Lordship. I produced the docket copy also at page number 61A. They disposed on Your Lordship, this is to inform that caption matter was registered on 27/6/2024 before the Honorable High Court of Karnataka. And Your Lordship, we have also informed the court that the petitioner, after obtaining the loan, till date has not paid the EMI and that outstanding as on today is so and so. After hearing both the sides, the Honorable Court disposed of the writ petition, directing the petitioner to appear and prosecute before the DRT and on the OA filed by the respondent within 3 weeks. Your Lordship, they have produced the page number 61A, Your Lordship, the docket of the advocate, wherein he has disposed on 26/6/2024, directing the petitioner to approach DRT within 3 weeks.
Appears to be in 6th of in June.
Your Lordship, we acted on the mail and also the document I have produced at page number 61A, Your Lordship. He has addressed a letter to us because what happened, Your Lordship, while getting the certified copy, it was delayed. The advocate has communicated to, as per Annexure R10, Your Lordship, that the matter was disposed of. After hearing both the sides, the Honorable Court disposed of the writ petition, directing the petitioner to appear and prosecute the DRT before DRT in the OA filed by respondent within 3 weeks. This is the communication received by the advocate on 27/6/2027, Your Lordship. Even I have produced the docket of the 61A, wherein he has written of disposed of on 26/6/2024, directing the petitioner to approach the DRT within 3 weeks. On the basis of the communication, Your Lordship, we have received we have gone ahead with the seizure of the vehicle. It is not that we have not committed any contempt, Your Lordship. Intentionally, we have not committed any contempt. He has addressed a letter to us. I produced the certified copies. Application was prepared. The advocate received the copy on 12/8/2024, Your Lordship.
page number 62. I produced R12, Your Lordship. Only on the communication of the panel advocate, we have proceeded with the matter. We had no intention to disobey the order of this honorable court. The advocate received the copy on 12/8/2024, page number 62, Your Lordship, and also as per the communication dated R10, we have acted upon. And Your Lordship, they, please
So
twin.
we'll frame a charge against the manager. On the next day. It's clear contempt.
Your Lordship, we have acted, Your Lordship.
Clear contempt and.
Your Lordship, may I take Your Lordship?
See
Page
this-
number 10, Your
see-
Lordship.
See your own reply,
10, Your Lordship.
page 8. Paragraph 20. I state that the bank manager with the assistance of Crystal Recovery Agency had seized the vehicle on 29/6/2014 and kept the vehicle
Your
in
Lordship,
their yard. This is after 12 months search of the vehicle went in vain. So Odessa is,
Your Lordship, may I take Your Lordship? One,
order is passed on which date?
26/6.
26 June.
Your Lordship, communication may take Your Lordship, page number R10, Your Lordship. R10, Your Lordship, communication. And page number 60 and 61A. We have acted only on the advice of the panel advocate, Your Lordship. May I take Your Lordship, page number 60, Your Lordship?
Whose letter?
This is some advice of their panel advocate.
No. From a panel advocate who is appeared in the before the single judge. After hearing both the sides, the Honorable Court disposed of the writ petition, directing the petitioner to appear and prosecute before DRT in the OA filed by the respondent within 3 weeks. Sir. Your Lordship, in the
First line itself is false, my lord. The matter was listed on 27/6, he says.
It
Matter was
not listed.
dispatched on 26/6.
It was listed on 26.
we have been guided by the Your Lordship, even the docket, Your Lordship, he refers, disposed of on 26/6, directing the petitioner to approach DRT within 3 weeks.
We'll address after recess.
I make a submission, my lord. Serial number 114, my lord. In this case, there is no office objection in this case, my lord. It's wrongly come to in office objection, my lord.
Already we given time, we have given time for 2 weeks, 2 or 3 weeks.
Notice has to go. my lord.
There is no office objection.
No, my lord. There is,
Why it is listed in the list of non-compliance?
no, my lord.
Law and advocate
There is no
system.
office objection, my lord.
114. 114.
Please, my lord, 114.
Law and advocate states that office objections are removed. The official verify. Thereafter post the petition after 3 weeks.
Notice may be issued, my lord. Notice may be issued.
No notice. Under the office objection, no notice. Once it is posted, then only. It is listed under the caption for office objection.
Yes, my lord.
So we recorded your statement that there are no office objections.
Short date, maybe.
It will come after 3 weeks.
Kindly, serial number 105, my lord.
105, yes. Somebody mentioned it tomorrow.
I mentioned it in the morning, Lord. I have informed the other side as well, Lord. I have paid the process as well. The interim order needs to be extended.
Should we extend? Extend over to which date? 11th February.
Grateful, my lord.
Serial number 128. Office objections have been complied, my lord. The only objection was with regarding to the names of the bank manager. Filed the amended petition. Amended file.
128.
128.
So what is to be done?
The objections was with regarding to the names of the bank managers, my lord. We have filed an amended. 128.
Law and advocate Ms. So-and-so stated that the amended, what amended?
Amended
Post title.
petition has been filed, my lord.
Amended petition is filed, therefore office objection is removed. The official verify and thereafter if the office objection are not, if there are no office objections in the matter, it will be listed after 3 weeks.
My lord's indulgence.
Pardon?
Date may kind of be.
Date is fixed after 3 weeks.
My lords, list 2, my lords have listed 5 matters. In that, one matter is urgent and
In all matters, instead of 3 weeks, give some date. Mention some date. January 27, 28. Any date in January last.
my lords, all the matters in second list, my lords, pertaining to SCST subject. My lords, my only request to my lords is the validity, my lords, has been heard. Learned Advocate General has completed his arguments and only the amicus curiae is also finishing his arguments. There's a request that if these matters may be taken up after vacation, my lords, if it's just a request.
Several.
Please, my lord, but now that the validity, my lords, it's almost concluded before the learned single judge.
Take a note of the order. The order is already uploaded also to 110.
Sir, we just want to request that if the validity is upheld, my lords, these petitioners may.
If it is held to be invalid, then either way it is on the ground of delay and legislative.
Is the delay aspect only is now. I just want to request, my lords, that if it could be taken after post vacation.
Why?
Lord, just in the interest of the
The interest of?
grantees, my lords, if the law is upheld, they may. Because it is already completed, arguments are completed, only amicus is replying, my lords, maybe we'll get.
So you mean to say that if the validity is upheld, then all judgments are wrong?
My lords, then we will try to convince.
So it is its own.
Please, I just wanted to request, my lords. Grateful.
My lord, submission, my lord, serial number 5. My lord, serial number 5, list number 2. In this matter, PTCL Act itself not applicable, my lord. Serial number 5, it is not maintainable under the PTCL Act, my lord. Because the land has been granted for an upset price.
Argue when it is taken up.
This is called.
ಮಾಡಿಲ್ಲ. Grateful.
Number 76.
The appeal for petition. Motion carried. The action of the bank, only on the instructions of the panel advocate, I have shown in page number 60 also. Now the bank has instructed me to state that they will withdraw all the actions of the bank. Because in view of the letter, your lordship, I have produced at annexure R 10 and 11.
I've been told that a vehicle has already been auctioned.
They will withdraw and restitute.
Yes, we will revert.
File affidavit.
Your lordship.
File your affidavit to the.
I'll file.
Learned advocate for the respondent.
First
stated that in defects and circumstances, bank is. Bank has decided to withdraw all the actions which are.
Not all cases. This particular seizure of the
All the actions
action.
in this case,
Yes.
which are in contravention of the directions of.
Hello.
Which are in contravention of the direction of law. All the actions which are in breach of the order of law.
Yes, sir.
Breach of. Stand out to
First week,
first week,
first or second week.
8th of,
Because I have to take the vehicle back.
8th or when,
20th,
16th,
20th, third week of January.
third week fall, 21st of January.
The passover matters, seal number 8. Seal number 8, Mr. K. Srinivas.
Learned advocate was absent in the first half as well as in the second session, in the larger interest of justice. Next listed on 11th February.
Seal number 12, it's a PAL matter. Mr. Murali Krishna Brahmanandam, party in person.
Same order.
Seal number 21.
Last one. Party in person has not been remained present since last 3 to 4 occasions. In that view, the justice is directed to intimate the party in person about the next date of listing of the petition to be on 11th February.
Seal number 21. Mr. Somasundar Rao. 21. Mr. Som Sundar Rao.
Serial number
21.
21.
Serial number ಎಷ್ಟು ನೋಡಿ.
Learned advocate for the appellant was absent in the first session. She was again the delay of 45 days.
Yes, 45 days. Therefore.
They were also absent in the second half of the day. Also, the appeal was liable to be, appeal oblique application was liable to be dismissed for want of prosecution. Is the last chance, 10 out of 20.
Number 42. 42 government appeal, my lord, passed over to consider the delay application.
Pardon? 42, 77 days.
One identical matter, my lord. Your lordship would dismiss the appeal of the respondent, government, my lord.
Appeal of the respondent.
Yes, I am for respondent.
Government's appeal.
I am for respondent number 1.
It is similar.
No, my lord,
It is similar.
Yes, my lord.
But the distinction can be drawn, my lord. I would request lordship, I will look into this judgment, my lord. I would request lordship to condone the delay and have it sometime earliest possible date, my lord. The distinction is possible, my lord. It is not arising out of the same department, in fact. This is some transference in.
The contention
The
of the
terms of employment were slightly different in this, my lord. We will make the distinction. My lord.
contention of the appellant is, my lord, appointment of the respondent number 1 is without prior approval, my lord. That is false, my lord. The annexure D in the writ petition, my lord, which is page number 83 in present appeal, my lord. This is a prior approval.
IA number. Oh, 3 of 24. Third learned advocates for the respective parties. By filing this application, delay of 77 days is said to be condoned by this appellant state. The passage of time is explained in the accompanying affidavit. The time is consumed in the procedural steps required to be taken by the applicant state authorities. In its decision-making process before it was finally decided at the appropriate before the appeal against the judgment and order of fairness in when the applicant appellant is state, the decision-making process, consumption of time is inherent to some extent viewed from this angle, and the reasons are administrative without any element of culpability, sufficient cause is made out to condone the delay of 77 days. Period of delay is condoned, application is allowed. Writ appeal may be listed on 18th February.
Good. So number 61, Mr. Ravi Shankar K. Number
My lord,
61.
I appear for the respond number 1 in this matter, my lord. I have filed the complaints report
None was present on behalf of the complainant in the first session as well as in the second half. In the larger interest of justice, stand over full stop. In the larger interest of justice, stand over to 25th February.
Number 63.
And the complainant, my lord. The accused number 2 has not complied the order passed by the Honorable Court, my lord. The one that relates to imposing the cost to my lord and as well as the arrears of the salary.
It was taken up in the first, what is it?
My lords, with respect to this, my lords, we have filed our compliance affidavit. So far as the arrears of salary, my lords, it has to be paid by the private respondent. It is a
Yes,
grant in aid, my lords.
This is,
Yes,
So far as we are concerned, the only direction is to take action against the private respondent, which we have done, my lords.
let's see. Let us see the direction. Page 29, 30. Now, who is for management?
management has not appeared earlier, my lord.
Somebody is appearing. Somebody is appearing. Some counsel is
In
appearing.
Honorable Learned Single Jury is not appeared, my lord. Before here, my lord, the
No, here.
name is
Srinath.
Srinath P.
Srinath B. is appearing. Inform.
yes.
19th.
Yes.
19th at 2:30.
This is number 70. Rajshekar S.
Direction is at page 23, my lords.
Who appears?
I'm appearing for the accused, my lords. 2 weeks time may be given, my lords. I'll file my objections, my lords.
Then what objections? You have to pay the amount of alimony. Out of said 40 lakhs, sum of 10 lakhs shall be paid by respondent within 3 months from the date of receipt of this court.
And even that 30 lakh rupees also, my lords, ordered to be paid.
10 lakhs are paid.
No payments are made. That even that 30 lakhs also, my lords, now 1 year is lapsed.
My lords, I'll take instructions, my lords, please.
In this, what is no instructions, only compliance.
My lords, I'll instruct my client to pay the money, my lords, please.
What is what your client is doing?
My lords,
What is he in life? Your client.
he's working, my lords. Working.
In what?
Engineer, my lords.
Engineer.
Please.
Not able to engineer the payment of money. Tell him.
My lords, this has
And you
been,
will take instruction.
2 weeks time may be given.
This
my
is for
lords.
compliance.
Please. Please, my lords.
Section for compliance.
I'll advise, my lords.
Section for compliance.
Please.
Learned advocate Mr. So-and-so appears and states that within the time which the court may grant, the respondents will comply with the directions of payment of alimony. At least the first installment as directed. 10 or to 7th of January.
This is number 71.
We dictated the order.
Please.
Tomorrow at 2:30.
Please, my lord.
Learned advocate was present, not present in the first half. As well as in second half, in the larger interest of justice. Since the order is stated to be complied with. Even first of order is stated to be complied with, then in the larger interest of justice, send over to tomorrow, 17. It will be stated to.
19 December 2030.
Yes. C number 82. To Vikas M.
Please, Lordship. Lord, the direction by the single judge was, the writ petition was to facilitate, continue my university PhD course. My Lord, the only problem is, my Lord, that there are 200 isolates because I am doing PhD in microbiology. And these are collected during the last 3-4 years. And my Lord, if I don't get that, and it is either it will be damaged or it will be pilfered, we are afraid, my Lord. We only want that. Then we don't want to continue with the contempt proceedings. What do you want? That isolate, my Lord, 200 isolates which have been collected, it is kept in the deep freezer. And my Lord, if we don't get it, I only want to continue my PhD. I don't want to insist on proceeding with the contempt. So as long as, my Lord, I get those isolate, because it is likely to be damaged or pilfered, because it is in the deep freezer. And I want to submit my thesis. And that is the order, my Lord. The single judge has passed the order as early as in June. But the direction is only this much.
Yes.
What you are saying is not the direction. No, my Lord? What you are submitting is not part of the direction of learning single judge. No, to facilitate was the order. To facilitate my PhD was the order of the judge. Read it. Read the directions. Hmm? Read the directions in the order of learning single judge. That is 70, my Lord, page 20. The submission that the petitioner's research work for her doctoral work shall continue with the university as is taken on record, and consequently the petitioner shall be entitled to access and use all the lab facilities. My Lord, the lab facility, there is the freezer, there are isolates of 200 lying there. I am not able to access it. I completed my 3 years. Once I get that, my Lord, I can submit my thesis. It is not part of, we can't read in between the lines. Yes.
My Lord, access has been given and facilities, all the facilities has been extended to her. This is, my Lord, there is ability and there is no direction. This is not even an argument before the learned single judge, my Lord. There is no direction also to that effect. Everything, all facilities has been given.
There is a direction. Why there is no direction?
No, direction, my Lord, to access and use the facilities that we have given.
You're not permitting access.
No, that is wrong, my Lord. That is
No,
not.
it is kept under lock and key. It is kept under lock and key.
No.
So how do we know? My Lord, we have several times represented to them. My Lord, without getting that, I cannot complete my PhD. What are those items? What are those items? What one? Huh? My Lord, these are, kindly see, my Lord. Here, kindly see page 16. These all are in deep freezer. Correct, but what are those items? My Lord, kindly see page 12, my Lord. What are those items? Items are, they call it isolates. These are required for it belongs to whom? I collected most of them, and partly I collected bought from the government agencies, and they will not supply again if I miss this chance. So it belongs to you? Yes, it all belongs to me, nothing of university. So how do you demonstrate that it belongs to you? Because there are letters and the orders, my Lord, along with this. So that you have to give back.
No, I
Page
do
number
not
3.
know, I do not, my Lord, I have no instruction on this, my Lord. I have no instruction on this, my Lord, whether it belongs to university
We
or
are
it belongs to
instructing
him.
you to give.
That is a question of
What
fact,
is
my
the
Lord.
question?
My Lord,
If it belongs to him, then you give back.
he has to establish, my Lord, I do not know, I cannot make any statement. My Lord, if it belongs to him, exclusively to the petitioner,
Correct.
then my Lord, he is at a liberty to take.
Yes, but then they have kept it lock and keys with them.
No.
Go before them and
Yes.
satisfy them that it belongs to you. My Lord, the orders are there by which I purchased. There are no orders. You have to satisfy them that this item or whatever it is there samples or whatever is belongs to him.
I have mentioned in the affidavit also, it's all belong to me, nothing of the, but the only thing is, my lord, that if I get that, then I have to finalize my thesis. And then I can submit my PhD.
Go immediately and request them.
Several times I went there to request, my lord.
No, with details of showing that it belongs to you.
Yes.
My lord, I can give a copy of this.
Not mere a statement. Something must be there to show that, substantiate your say. There must be something to substantiate your say that these items belong.
No, they are not denying it, my lord, it is belong.
No, I'll file my affidavit. Can you?
Eh?
No, that is not the point here.
The isolates are belonging to me as not denied by them.
But
These are not execution of
that is that,
manageable.
yes.
What do you say about, if it is belongs to him, then we will return them.
Lord, if we, my lord, I do not know, because she's a student of PhD.
Find out from your client.
Yes, my lord, I find out and I'll file an affidavit. Lord, it is for the petitioner to complainant to establish that belongs to them. Let them go to the authorities and say.
No,
if
you
they-
find out it.
Yes, my lord. Because that was not the.
My lord, this
Just
is,
now they have given here. Just now their copy has been served. I just
What,
find out.
what today have given something?
yeah, the orders are there by which I purchased and it belongs to me.
Yes,
Kindly
yes.
see page 3.
That is exactly wanted, yes.
Yes, my
Okay,
lord.
verify.
Yes, my lord.
Page 3.
It does not say, my lord.
My lord, in microbiology, these are to be collected, even purchased by me. The remaining I create it. Thereafter, I submit my thesis. But everything is done. But my lord, what happened was, my lord, there were 2 guides. The previous guide has kept the key, which they are not able to release it. Without that, my lord, it will be damaged. It is all temporary. Kindly see page 13. And 200 of them. It is very difficult to recollect it. Page 12, my lord, Annexure C is the photograph. This is all collected by me during the last 3 years. And some of them only purchased, which is that order is there at page 3. The purchase is also at a B, page 5. And at my cost.
Are they identifiable?
Identifiable, my lord? Yes.
In what way they are, how can you identify?
My lord, it is kept in a particular portion of the freezer. And if I get access to that lab and the freezer.
Your student, give access to him. What is?
No, access has been given, my lord. That is not denied. In fact, that was the case before the trial,
No, you
before the
take
right single judge.
This is not the case to fight out.
I know, my lord.
So give if it belongs to a student, these samples and the material shows that he had brought them.
With a lot of difficulty, we collected, my lord.
Material produced today at least shows that she or he had brought them,
Yes. I'll find out. my lord.
purchased them.
Yes, my lord. Maybe.
Find out day
Yes,
after
madam.
tomorrow at 2:30.
That is.
Go to paragraph
That
3.
may be for the purpose of her PhD, my lord, for a research work.
Paragraph 3, paragraph, page 3, page 4.
So and so and so. Chemicals in Almara as requested by them in all laboratories under the jurisdiction of the concerned student. And revise research supervisor and previous, I'm sorry. And that falls under the personal research scope. So if it is a personal research thing, my lord, she may be
Is
entitled.
there any difficulty in returning them?
I do not
Even
know.
otherwise?
Yes, my lord. I do not know, my lord. I'll just find out.
My lord, it is only to make available, my lord, because it has to remain in the freezer. And
If she takes, my lord, that I don't know where she will
and
keep.
we have you have to use it so that I may.
For the purpose of research work he needs.
Yeah, only for that purpose.
That should be in the freezer only. That cannot be outside.
That you technicalities we don't know. We are not expert.
But
That's
the
true.
previous guide has kept a key and disappeared, my lord. They are not able to
Keys
procure.
has been given, my lord. In fact, a legal notice was issued. A reply has been clearly mentioned, my lord, the legal notice.
We don't see any room for argument in. You find out and solve.
Yes,
the
my
issue.
lord.
Day after tomorrow. Day after tomorrow at 2:30. Next.
Much obliged.
Bill number 97. For respondent number 3 in this case.
Petition. May it please, my lords. The petition is a sequel to a series of earlier petitions. Way back in 1992 to 96, the BBMP allotted for a consideration apartments, built apartments and sold them on a lease cum sale deed for a consideration of 30,000 and collected about 10,000 rupees from each and executed lease cum sale deeds. By 96, 97, my lord, 2 of the buildings collapsed. And the government evacuated the 1,512 families to the streets with a promise to rebuild the land, rebuild the apartment, which never happened. A division bench of this honorable court directed the government to BBMP to rebuild it, which was not obeyed. On the contrary, the BBMP entered into a public-private partnership to develop part of the land for EWS project and commercially develop the rest. As against which another writ petition was filed.
So what is the grievance today?
My lord, what has happened is, since despite an order passed in 2012 for BBMP to build the land, develop the apartments through the developer, to this day, no progress at all. And there was a recent order in 2023 also. What has transpired now, my lord, is that the developer has mortgaged 50% of the land and has committed default and is facing proceedings and IBC proceedings before the NCLT, insolvency proceedings as such. The purported lender has brought the land for sale, issued a notification as section 13.2, followed by 13.4. We filed an application in April for cancellation of the concession agreement because it's a gross disobedience of the order. Because of the development, we filed yet another writ petition before the learned single judge, challenging the 13-2 notification. This Honorable Court, learned single judge directed us to file an objection to the 13-2 notification. Despite that, they went ahead with 13-4 notification. We were asked to go and object that before the Debt Recovery Tribunal. We have filed an application before Debt Recovery Tribunal, which got dismissed on Friday as non-maintainable. The process is, my lord, the land does not belong to the developer or even BBMP as observed by this Honorable Court. There was an investigation was initiated by the Honorable Lokayukta. A Lokayukta report has also been filed with a clear finding that the BBMP could not have given consent to mortgage the land to a bank or a third party as such, because there is a condition passed by this Honorable Court that if the developer fails to construct the apartment within 2 years, the concession agreement has to be cancelled. So without completing the EWS project, they could not have gone ahead and mortgaged the land with respect to the rest of the property. This is the situation. My lord, since 96,
Who has mortgage?
the developer has mortgaged and BBMP has illegally granted concession, and the Honorable Lokayukta has directed the government to take action against the then commissioner for acting. I'll pass on the.
Who will appear?
I appear for BBMP, my lords. This, earlier, Mr. Puttegoda used to appear. He's severely unwell. He's issued a NOC. I am yet to file the Vakalat, my lords. Short date may be granted. I'm coming for the first time on record in this matter.
What is the urgency?
My lord, the property, 13-4 notification, the SURFACE has been obtained. Third party right will be created. I went immediately before the Honorable Single Judge. The matter is listed today in B group, which is unlikely to be reached. Where what we have done is, we have challenged that. We have filed, we were asked to go and appear before the Debt Recovery Tribunal. Debt Recovery Tribunal dismissed my application as not maintainable, saying that I have no locus. Where do we go, my lord? 1,500 family. I've been fighting this case pro bono for past.
Here the prayers are on a different line.
Which one, my lord? My lord, 2024, 18-504 is a subsequent petition that I had filed. An earlier petition is in 2011. That's
Who appears?
Malad, I appear. Malad, I'll have to seek instructions because this is coming up after a long time.
May I also pass on the Lokayukta report, my lord, which very clearly is a finding that mortgage should have not a.
This is that one.
Let them take instructions.
Pardon, my lord?
Let them take instructions.
Short date may be given, my lord, because until then, status quo of the land should be maintained, my lord. Because third party right is created if the bank sells the property, nothing remains, my lord. This project cannot be implemented. Where's my?
Right now, the proceedings are before NCLT.
NCLT's proceedings against the developer for being insolvent. The developer has purportedly mortgaged the land and taken a loan with the consent of BBMP. The non-banking finance company has initiated 13 proceedings and 13-4 notification has been done. I filed a writ petition, my lord. I'll be much grateful. Even the petition may be taken on.
13-4 of SURFACE.
So again, SURFACE. The DRT rejected our application saying that we have no locus. And then because it is 100 crores, one has to go and fight somewhere else in Chennai. All that is there. But immediate problem is, my lord, there's a finding by the Lokayukta. BBMP could not have given consent to the developer to mortgage the land.
So now what is the next step you're apprehending?
My apprehension is, my lord, that 50% of the land, if it's sold by the borrower
Sale is
the
announced.
project cannot be completed at all.
Sale is announced.
13.4 notification should be followed by sale. That is the reason status quo may be maintained, my lord.
It is issued, 13.4 is issued or not?
Yes, ma'am, I received and I challenged it by before the,
Then it will be auctioned.
it should be auctioned, my lord.
It is notified, that is.
Notified, my lord, yeah.
Auction is notified.
No, auction notification is not.
Once the auction is notified, we'll give result.
My lord, at any moment, 60 days has already lapsed. Any time it can be happened.
Auction notice is not issued.
But my lord, there is kindly see the observation of the Honorable Lokayukta. I'm just passing. I'll give a copy. Right. Serve a copy. Yes. First, you. Lokayukta report.
Yes, okay.
Remove those.
Yes, and this is it.
Give a copy to
Yes,
them.
that's for justice. Just for arguments. This is okay.
That's okay. May I take my lords to page 119 of the report, my lord. Or page 118, my lord. In page 180. Mayor. Page 118, insert paragraph 17, disposal of property and interest therein. Notwithstanding anything contained in this act, no movable property exceeding such sum in value as may be prescribed shall be sold otherwise than by public auction. B, no property, whether movable or immovable of whatever value, shall be transferred free of cost or for any upset price. No lease of any immovable property exceeding 5 years shall be granted. No immovable property shall be disposed by sale or other except with the prior sanction of the government. The reading of subsection 6 of 176 of the Karnataka Municipal Corporation Acts 1976 referred to above shows that it is not permissible for the BBMP to create mortgage of property belonging to the BBMP and effecting a change of khata in favor of others without prior permission of the government. The question is as to whether such prior permission was granted by the government permitting BBMP to create a mortgage of the said property in favor of India Bulls Finance Company by means of deposit or title deeds. The government, by means of its notification dated 26/9/2000, has only authorized BBMP to enter into a joint development agreement. BBMP, by means of its letter dated 6/4/2015, had only informed the Additional Chief Secretary to Government, Urban Development Department, Government of Karnataka regarding the execution of second amended agreement dated 2/12/2014. There is no material on record which prima facie shows that either BBMP or MHIPL has obtained the prior approval of the government in terms of 176 of the Karnataka Municipal Corporation for creation of mortgage of the rights of MHPL in favor of India Bulls Company. Therefore, its prima facie appears to me that fastening the liability of the property in question by creating deposit or title deed is unauthorized and without the authority of law, and will not create any right on the property of BBMP in favor of India Bulls Housing Finance Limited as a security for loan advanced by MHIPL. Subclause 6 of Section 176 of the Act is mandatory in nature, which is intended to protect the valuable rights of Bangalore Mahanagar Palike property in which the state as well as the members of public have a right. These are all the matters of which government is required to consider. So despite this,
Who is going to hold auction? BBMP.
BBMP, man. India Bills, man. What has happened is BBMP has given a consent for the MHIPL, that is Maverick Holding,
India Bull.
in favor of India Bulls. India Bulls, now they have changed the name to
is
Saman
for India
Capital.
I appear for the developer Maverick Holdings. I appear for the developer Maverick Holdings.
No, who is for India Bull?
India Bulls is coming to picture only now, my lord.
No. So you join?
Pardon me?
You have to join them as
I will join them, certainly join them. I have to join them. But they have made party in the connected writ petition, my lords, before the Honorable Single Judge. I'll be much obliged and grateful if the said records are also called for and heard together. Because the learned Single Judge already expressed an opinion that matter should also be heard before this Honorable Court. It is WP 26-384 of 2024, where India Bulls has been made a party.
So BBMP has already created a mortgage.
Pardon me, lord?
BBMP has created a mortgage.
Yeah, they created mortgage jointly with the borrower, my lord.
Developer.
Exactly.
Your mortgage?
The consequence, my lord, is that this is about 18, 19 acres of land, which was belonging to 1,512 families belonging to the weaker section, economically weaker section. By way of a compromise, because of they were living in the streets under sun and rain without any shelter for nearly 12 years after being evacuated, we are arranged, this honorable court suggested something should be done because BBMP said they don't have money to do the project. So we agreed on a compromise saying that at least you develop this first and then the thing, which has not happened.
Are you able to take instruction day after tomorrow?
Yes.
Day after. You'll see on that.
Yeah, my lords, I'll be grateful if this matter also called for taken up together. WP 26-384. There's an order passed in the first writ petition. Anything pertaining to the land, this project should be heard by this bench.
19th.
Will
Other
this-
petition is listed today?
It's listed today, my. What is that? Can we on 18th, my lord? I have convenience on 19th. I'm traveling to Delhi, my lord. 18th.
Try it in time permits. They will be able to take instruction.
My lord?
To find out what is the status of the
I'll do that.
things.
May I request, my lord?
And if this matter is also listed along with the 26-384 of 24, my lord.
Session.
Listed.
Much of it.
18.
Lord, may I, instead of day after tomorrow, kindly insisting that I should be here, can it be on the reopening?
Reopening. Which matter? 70, 83, 83. 83 में आपने लिया है. You have taken the 83 का order. Who has taken the order? So 83, 6. No, 8 January. That's right.
This is serial
Want to
number
keep the number.
82. It's for
82.
Much of that.
What of 26.
Number 104,
19th.
the mentioned matter.
18.
Much of it.
No, I appear for the appellant in this matter, my lord. This is a matter, my lord, relating to an Inam,
Yes.
Personal and Miscellaneous Inam's Abolition Act. And the Inam was abolished.
This was the matter which was urgently circulated. No. Somebody mentioned.
What is 26?
Because anyway, what is the matter?
Yes, my lord. Now, my lord, one person called Kemparaju says he's entitled to 160 acres of land. As your lordships may know, my lord, under the Personal and Miscellaneous Abolition Act, once the land vests with the government.
No, which is that section? Which is that section?
Yes, section.
Inam abolition.
Inam, Karnataka Personal and Miscellaneous, Inam's Abolition Act, section 3.
That appears to be the crux of the.
That's the crux of the issue. Once the land vests with the government,
I need to file objections. I have not filed objections for the interim order that has been sought for. I need to file objections. Like it may give a week's time or 2 weeks time. I'll file.
but there is some urgency.
Urgency, because
The urgency is the court, one second, sir. Court has not merely granted rights in favor of the person concerned who has not even made an application.
See, what is that section?
Please see section 3, my lord. Inam's Abolition Act.
Email. Nineteen 56 Act, sir.
54 Act.
Mysore.
Mysore Personal and Miscellaneous, Inam's Abolition Act.
Page number 49.
You are the heir of, whose heir?
My lord, I am, my lord, the heir of one Kempaiah who had,
Kempaiah.
yeah, who had originally purchased the entire village.
49.
Oh,
This
Cap,
is 50
what is
acres.
that word?
Beg your pardon, my lord? It's a village of about 498 acres.
No, no, that's right, but. Todidar, what? That some word is coming. Anyway, yes.
I had purchased not this entire extent of land. The claim is that a portion of it had been mortgaged to one Doddaya.
But then who is in possession?
We are in possession. Kempaya is in possession of the entire extent, of the whole
Total.
extent, whole extent. As a matter of fact, land tribunal granted all rights to us. But of course, because of land ceiling, it said you are only entitled to whatever is you are entitled to under land ceiling.
58 or
54 acres of land. About
What is
54.
the total land?
Total is 498 acres.
498 acres.
498
And you are
acres.
claiming 498 acres to be occupancy. right?
Yes, no.
490.
498. And the land tribunal held no one else has any rights. So what the consequence of it is subject to, of course, determination of actual land ceiling. There'll be a determination of how much and who is entitled to what. There were several claimants. One was one Kempaya. Then there were three others who were my brothers who also made a claim for portions of the land. And one person called Kemparaju. Kemparaju, my lord, never filed an application as required, my lord, under the Act for the purposes of grant of occupancy rights in his favor. And that is the admitted position till the very end. But the order now has been that in respect to everyone else's rights, it goes back to the land tribunal. But with respect to Kemparaju's rights, this honorable court has made the declaration. Can I request, my lord, look at section 3, my lord, consequences of vesting of Inam.
So your, this appellants are Inamdars.
No, no, we were the purchasers from the Inamdars and therefore purchasers from Inamdar, and therefore we become or step into the same shoes as the Inamdar, and therefore we are entitled to make a claim for occupancy rights. My lord may see 3B, my lord, first. All rights.
This goes against you.
Beg your pardon?
This goes against you.
No, what happens, my lord, is as soon as the land vests with the government, all persons who had rights over the land loses the right.
How do you claim?
Then we make an application.
Where is that?
That, my lord, your lordship will kindly come to section 4 first. 4, 5, 6 and 7.
For occupancy rights.
Occupancy rights. So there, my lord, from 1959 onwards, this entire proceeding has been going on. And the rights of Kemparaju have always been rejected, saying he has never made an application. If your lordship kindly see, the last date, my lord, was ultimately 1979, and then it was extended once more. If you don't make an application, your right is gone forever. Please see, my lord, section 4, just as an illustration, my lord, because there are several sections which give certain different characters of persons to make applications. 4 is a Kadim tenant. Every Kadim tenant of the Inamdar shall, with effect on and from the date of vesting, be entitled to be registered as an occupant in respect to all lands which immediately before the date of vesting were properly included in his holding. Then, Lord, please see section 5, a similar provision for permanent tenants. Then the process, my lord, by which it can be done is, my lord, in section 10.
Jodi Inam.
Jodi.
That is what is that Jodi? When I was reading this, yes.
Jodi is joint, Lord.
Joint, joint.
Then let this records destroyed.
So you are a tenant or occupant?
No, I'm an occupant.
Okay.
Occupant. The tenants, my lord, are those who claim under me as tenants. Therefore, whoever are tenants will of course have a right because of our tenancy laws, my lord. The tenants will have a right with respect to the property of which they are occupation as tenants. Now, interestingly, the person who claims and whose claim now, my lord, has been accepted by the learned single judge was neither. He said that he purchased it from a person who had filed a civil suit.
93. What is that civil suit?
The civil suit, not also recovery of money.
Recovery.
Recovery of money from Kempaya, that is myself. Then, my lord, that property was brought to sale.
Your Kempaya.
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 LRs of Kempaya, now, my lord. Kempaya, of course, from 1959, he's passed
You are
away.
saying you are Thimaya.
I beg your pardon, my lord?
You are saying you are Thimaya.
Kempaya.
Kempaya, not Thimaya.
Not Thimaya, Kempaya. Now, my lord, Kempaya, there's supposed to have been a mortgage in favor of one Dodda Raju. Dodda Raju filed a civil suit.
This requires. What do you say?
Now, question is your lordship, my kindly see. I have purchased the property in a court auction which was attached. Under section 64, any alienation, private alienations, during the pendency, the attachment is void. Now he says, I have not filed application. There is a record to show that the entire records were destroyed. They did not even make an attempt to build up the records. There was a direction by this court to build up the records. And now.
But the answer is in section 3F, nothing more, my lord. Please see section 3F. My learned friend's entire argument is answered in 3F.
No such Inam is liable to attach.
Attachment or sale in execution of any decree or other process of the court, and any attachment existing on the date of vesting or any order for attachment passed for such date in respect to such Inam shall, subject to 73, cease to be in force.
No, it doesn't apply because, I'm sorry, I haven't got the act also. It says it's subject to section 73 of the
attachment to
transfer of property.
But attachment is subsequent to the date
That's
of the,
what I said. I mean, it's subject to, is not object to. That's why the court has dealt all these things and said that my purchase is by virtue of the attachment in a civil suit for a recovery of money. And then property was brought into auction. I purchased. In 1953, there was an attachment by the court. In violation of the attachment, he has purchased the property. And your lordship may kindly be aware that section 64 may mandates that any private alienation is void.
doesn't apply.
Anyway, I'll file a detailed objections, my lord.
But then we'll hear this matter.
But let them not do
What
anything.
affidavit need to be filed?
Beg your pardon?
This appeal, what affidavit in appeal?
Everything is on record, my lord. All documents are on record.
And I think there are two more writ petitions. So all the three writ petitions heard together.
Let them
Now
not do anything
only
pursuant
one
to
writ
this order.
petition order, one is challenged.
So you are in possession, there is no dispute.
No, can't be. I've been in possession from 90. First time he's coming now in 90s and making an application.
We'll sit down for here.
Very well. Lordship may only say that.
Senior Advocate Mr. Yan Chinnappa, assisted by learned Advocate Mr. So-and-so, so the appellant. And learned Senior Advocate Mr. So-and-so, so-and-so, who appears upon caveat or advance copy.
Yeah, caveat normally.
On caveat.
Notice has not been ordered to other respondents, if I am correct. It's only filed a caveat, so it's there.
On caveat. The appeal arises out of common judgment and order dated 27th September 2024. Passed in group of writ petitions insofar as the judgment and order relates to writ petition number 274, is it correct? 27049?
27409. 27409
409.
of 17.
2740917. The said writ petition came to be allowed. While on a single judge who passed the following order, following operative order. This, यहाँ से यहाँ तक 126. The dispute surrounds round to the land bearing survey numbers 12104 situated at Telamakunte village in Jodi village. It was an Inam land.
Inam.
Yes,
It was an Inam
No
land.
dispute.
Jodi village.
And governed by the provisions of the Karnataka. What is that law?
Karnataka personal and miscellaneous
It
Inam's
is
abolition.
Karnataka or Mysore?
It was Mysore, Malad, then of course, after state
Now
reorganization is now.
Karnataka Inam's Abolition Act 1956,
54 and 56. 54.
1954,
Rules of 55.
55. Where is that act name? One second.
54 or so.
It is Mysore, sir. Is Mysore?
Mysore, Malad, still showing as Mysore.
Mysore Integrated Personal and Miscellaneous Bracket or Inam's Abolition Act 1954.
Mysore person.
The appellants happen to be the heir
Yes.
of one K.P. Ramaya.
Kempaiah, Malad.
Kempe.
Kempaiah.
Kempaiah, where is that name?
Malad, serial number 3, Narayan Gowda, son of Kempaiah.
The land belonged to, the land was a Inam land, of which one K.P. Ramaya was a Jodidar.
KP Ramaya was a Jodi. Correct, correct.
K.P. Ramaya was a Jodidar. The said Jodidar effected sale of the land. And the land passed several hands.
And purchased by Kempaiah.
Purchased by Kempe. Purchased by Kempe.
The land was subsequent, at one stage purchased by Kempaiah. Also, the provisions of section 3 of the Act of 1954 Act operated, and under section 3 into bracket B, all rights, title and interest which were vested in the Inamdar came to be absolutely vested in the state of Karnataka. Full stop. It is the case of the appellants here in that thereafter said Kempaiah.
No, not thereafter.
Not thereafter.
After before it vested, I purchased. After it vested, not the others are claiming.
You purchased it.
I purchased it before vesting. So there's
Then
no dispute of the
before
fact that I owned the property.
His purchase was
Section
while
3
the attachment was pending. Attachment was in force.
3 did not operate.
Beg your pardon, Lord?
Section 3 operated or not?
Section 3 did not operate when I purchased. Because I was the owner, thereafter, my lord, I'll tell your lordships, the date is, if my lord kindly comes to 25/6/1956, I purchased this entire land.
Purchased on 25/6/1956.
1956. And the date of vesting is 1/2/19.
Kempaiah purchased the land.
Kempaiah.
Yes.
Yeah.
And the vesting will not happen on 1/2/1959. All their claims are afterwards.
So your case is vesting will not apply to you.
No, vesting applies to me as well. But I made an application subsequently that the lands be
That's what.
allotted to me, or I be declared as the occupant of
No.
those lands.
Then
His-
section 3 operated, not
he-
operated.
It
But-
also applies to him. It also applies to him.
Section 3 applies to everybody. my lord.
Everybody.
The entire land vests in the government. After the land vests in the government,
Thereafter, the 1950, thereafter you purchased before 54 Act.
yes, no.
When?
Before 25/6/1956. But under the Act, my lord, the land vests upon a notification being issued by the government. That notification was issued on 1/2/1959.
Which was 56, which was before 1/2,
1959.
1/2,
1st February 1959.
1/2/59.
My lord,
It is the case that therefore the consequence of vesting would not apply to the person. Is it so?
No, my lord.
No.
I'm not saying that.
Therefore, it operated.
It operated.
So-
Therefore, land went to the government straight away.
Correct.
Then
That
I
is-
made an
so,
application.
paragraph. In view of the above, section 3 of the Act operated under subclause B of subsection 3 of section 3, comma,
Section 70.
the land vested absolutely with the state government
With the state government.
in respect of the all rights and title which was available to the Inam.
Yes.
It is the case that thereafter the said Panchayat
Empire.
made an application under section 4 of the Act 4 and 5.
6. No, no. Sorry,
There is a checkered text and therefore.
Yes, yes. I'll give you lots of entire table of the facts, Lord, as to who because there have been so many proceedings.
While
which have
we
gone on.
recording, we'll say we'll made an application
Application.
under the provisions of the Act
Under the provision.
for the purpose of
Fine.
for the purpose of grant of occupancy right. Is it correct? Occupancy rights.
Occupancy.
Occupancy rights. And who is the client of the other?
There, my lord, the story is that after the date of vesting.
Not it's a
One
story, it's a
second.
fact. It's a fact.
Okay, okay.
Not a
whatever.
story. I'm sorry, it's borne out by the records.
I was thinking of my story and your story, sir. So it is the same thing.
Your
Story
case you
only.
can say, not story. Anyway.
Anyway, according to us, my lord, this is the story. What happened, my lord, is after the date of vesting, in a sale conducted by the court, his client purchased the property. That couldn't happen under section 3F. Because after the date of vesting,
No.
all attachments which existed
Could you-
ceased to exist.
Could your lordship kindly see, in 1953, in a suit for recovery of money, 160 acres was attached before judgment. In view of section 64, any alienation subsequent to the attachment is void. Section 64 of the CPC, your lordship may kindly see. So as such, his sale to the extent of 160 acres which has been granted to me is void. Your lordship may kindly see section 64 of CPC.
But this is not subject to 64.
It was, I mean, all this borne out by the records.
The entire property goes not to the government. There's no question of anyone else making a claim.
They say. His sale to the extent of 160 acres is void on the day he purchased the property. Section 64 of CPC, your lordship may kindly see. What is CPC? 64, your lordship may kindly see, CPC.
64 transfer property.
Hmm?
Yeah, CPC.
CPC. Section 64, may I read your lordship? Where any attachment has been made, any private transfer or delivery of the property attached to any interest then and any payment to the judgment debtor by way of a debt, dividend or other monies contrary to such attachment shall be void. The law says it's void. His purchase of the property in 1957 was void because 1953 there was an attachment.
What is void? Void is any money contrary to such assignment is void.
So doesn't apply, my lord, because this is not Inam's Abolition Act is a special act. And under special act,
No,
there's a
CPC
vesting. How
CPC
is
is
CPC
not excluded from
Alienation of the property after attachment to be void.
void. That's what I see. 57 he purchased, 53 there was an attachment to the extent of 160 acres.
But in the meantime, the Inam mobilization
The act
kept
came.
Yes.
So the entire thing became void. I don't know. There's
So,
no attachment left in law.
Now the question is, your lordship, whether he could be granted 494 acres when 160 acres was held to be void under law. The question is, as far as the remaining extent, I am not concerned. So far as the 160 acres is concerned, the civil court had attached it before judgment. In 53, it was attached. So if it is 53 is attached, if 56 he purchases 494 acres, the sale to the extent of 160 acres is void. And when it is void, he can't make an application subsequent to for regrant of the property.
That will exempt. As against the above, the case of the original petitioners who happen to be the heirs of one T. Kemparaju is that Kemparaju purchased the property
Yes.
pursuant to an auction conducted in view of the decree passed in one original suit number 93 of 1953.
Purchased in 1966. 27/7/1966.
Purchased in on
Purchased, my lord, on
17th May 19,
27/7/1966 by one Doddaya and then sold to Kemparaju in 68. My lord, see,
as against the case of the, just tell the facts, case of the original petition is that the land in question came to be purchased by one
Doddaya
in an auction conducted in view of the decree passed in original suit of 93 of 1953. Full stop. From the said Doddaya, the Kemparaju purchased the property
21/3/1968.
on 21/3/1968.
1968.
Full stop. It is accordingly that the original petitioners claimed rights in respect of the land, rights and interest in respect of the land. Where it was contended on behalf of the appellant herein that once the provisions of the Inam Abolition Act 1954 intervened to operate, and the occupancy rights came to be granted to said Thimaiya, they would continue to hold good in eye of law.
Yes.
To operate as valid as against all subsequent actions of transfer. On the other hand, learned advocate Mr. So-and-so, who the original petitioners respondent herein, would rely on section 64 of
Civil Procedure Code.
Civil Procedure Code 1908, which contemplates that the private alienation of the property after resettlement be void. Full stop. In the controversy highlighted in brief above, as above, from a contentious issue arise requiring to be gone into in detail. Full stop. It may be the moot question whether the provisions of the Inam Abolition Act would override section 64 of the CPC.
Correct.
As it would be submitted by learned advocate of the appellant, senior advocate of the appellant, that the Inam Abolition Act is a special act and deals with special area of rights of the parties. Full stop. In the above, appeal deserves to be finally heard. It is admitted to be posted for final hearing when?
Anytime of January.
Second week of January, Your Lordship. First week is the holiday. Second week, Your Lordship may have it any day, convenient to the court.
th of fifth of March.
March.
Wait.
5th of March.
There'll be a stay on the order.
No, stay I oppose because no, even assuming that he is aggrieved, his grant is only 59 acres.
Only thing that
It's 59 acres.
Where is the question?
as the prima facie case is made out, by of interim relief, the impugned judgment and orders are even stayed, and the direction regarding mutation of the name of the legal representatives of T. Kemparaju in respect of the land to the extent of 160 acres shall remain in abeyance.
Grateful. I'm grateful.
Abeyance will be all right.
Yes, yes. I'm grateful. Very
In fact, I mean, he couldn't have any grievance.
We'll thresh out. It is interesting.
He's even assuming that he is granted only 59 acres.
There were way 1
54
minute.
acres.
He has no right. He has no right at all.
It is further ordered that the parties shall maintain status quo with regard to subject matter.
Let's wait.
Both.
One bit.
Any office objection is there, shall be, if any objection is there, it shall be removed before the next week.
Number 145 for withdrawal of contempt.
Lord, I am given to understand that they've complied with the order of the learned single judge, and in regards to the same, we seek to withdraw the contempt proceedings.
Figures on the record of the petition memo dated 7/6/23 filed by learned advocate for the complainant. Which reads as under for the memo. In your the memo dismissed as withdraw after quoting the.
Number 146. Mr. Ramchandrayan.
Same order. Memo dated, whatever.
Number 147. Varun, yes.
On the last occasion, I had taken my lot through the position of law on the point relating to the scope and jurisdiction of a court under section 37. Here we are faced with a situation where the arbitral award is in my favor and the award has been confirmed by the section 34 court. In such an eventuality, the approach of the court being to uphold the mandate of the learned arbitrator. The jurisdiction of the section 37 court at earlier points in time in 2019-20, the Supreme Court said should not act as a court of appeal, should exercise restraint, etc. But as time went by in 2023 and as recently as earlier this year, the Supreme Court has said in so many words that unless there is cause to interfere, you shall not interfere, even if there is an error on fact, unless the discretion exercised by the learned arbitrator is such that it's absolutely untenable in law. If it is otherwise permissible, then there is no cause for this court to interfere, that too in concurring judgments. That is the position of law. The judgments have already been produced. Lord, the appellant has taken my lord through the facts. I just take my lord through some of the relevant documents. If volume 2 could be seen, my lord. Volume 2 of the appeal memo, the settlement agreement and the correspondence, which led us to the arbitral tribunal. The endeavor, my lord, now is to show to this court that when the proceedings started and when we were before the learned arbitrator, these were not the arguments that were raised before the learned arbitrator. There were some pleas, there were some pleadings, but these were not the grounds urged before the learned arbitrator, nor was this plea raised vehemently before the section 34 court. The judgments don't reveal that. It's only before this court now, from as I gather, two primary contentions have been raised. One, that there is absolute ignorance of the fact that apparently some penalty was imposed.
What were the arbitrable disputes precisely referred?
Well, the arbitral dispute that I referred to the arbitrator was only this specific performance of the contract of settlement agreement.
Specific.
I'll take my lord through the agreement and the section 11 order of this honorable court appointing the arbitrator where the scope of the dispute was identified. I'll take my lord through that. What I sought before the learned arbitrator was specific performance of the settlement agreement, that you have agreed to pay me X amount, pay me. That's all there was to it. Their argument before the learned arbitrator was completely different, which appears to have been given the go by now. What they sought to contend before the section 11 court, before the arbitrator, when the arbitral tribunal had to be constituted, and before the learned arbitrator was two other arguments altogether. And that's reflected in the records. One of the arguments was that the invocation of arbitration is premature. That the settlement agreement contemplates conciliation proceedings between the parties, and only upon failure of such conciliation proceedings, then arbitration can be resorted to. The contention raised by the appellant then was that I have not followed the conciliation proceedings, directly resorted to arbitration, and therefore the invocation of arbitration is incorrect. That seems to have been given the go by now because that has not even been mentioned here. That has been dealt with by the section 11 court, dealt with by the learned arbitrator, dealt with by the section 34 court also. The other contention vehemently raised before the learned arbitrator was that the dispute is tainted by fraud. Fraud is inarbitrable, and therefore the learned arbitral tribunal does not have jurisdiction. The learned arbitral tribunal's finding is there that fraud was contended in a criminal complaint. It is not contended in these civil proceedings before the learned arbitrator. While filing the criminal contempt, I said you have committed fraud in diverting the funds from that escrow account. That is the element of fraud. The learned arbitrator has given a finding that that is not something that vitiates the entire transaction, and it is not one that requires complicated evidence, And therefore, Ayaswamy, the Supreme Court judgment, will not come to their rescue. It may not be applicable in the facts of this case and says that no, there is no fraud here. Criminal complaint, if there is any fraud or anything, the criminal trial can go on separately. These were the grounds urged then. These were the grounds reiterated before the learned district court under section 34. Here, my lord, now argument is being sought to be raised that penalty was not ignored. The obligation to pay 23 crores is conditional. Lord, these were not even pleas. And anyway, I have an answer to that also. The other argument raised for the first time now before this honorable court is that the settlement agreement has been given the go-by because my cumulative relief that I seek before that I sought before the arbitrary tribunal amounted to 37 crores, which is 23 crores plus the 14 crores damages that I seek. Therefore, having claimed the amount that was otherwise due to me, I am deemed to have given up the settlement agreement. These are the arguments raised now. The records will show these are not the pleas. These are not the arguments. And is it in arbitration jurisprudence permissible for a party to come and raise such arguments now? The answer is a straightforward no.
What argument?
The arguments that were not raised before the tribunal. Pleas that were not urged before the tribunal. In the pleadings, in the statement of objections, my lord, drafting, everything is mentioned, all and sundry.
Is that argument not urged before tribunal?
Twofold. One, penalty being a part of the contract. The
What penalty?
penalty. Sharing of penalty being part of the contract, the obligation to pay was conditional upon such sharing of penalty. That it was a conditional obligation. This is one proposition. Of course, well, yeah, appellants may clarify, but this is what I have understood as being their proposition. And the second argument, which I submit was not raised before the learned arbitrator, is that the claimant is deemed to have given up the settlement agreement.
That was not urged.
That was not urged. No, the reading of the arbitral award will show that. He is deemed to have given up the settlement agreement because the cumulative amount of claim sought by the claimant is 37 crores, which was a subject matter of the settlement prior to the arrival of the settlement, prior to the execution of the settlement agreement. Subject to correction, my lord, plain reading of the records will show. In their state, I will reiterate this. In their statement of objection, somewhere here and there, words will be found, sentences will be found on these points. Was an issue framed by on this issue on these two pleas? The answer is no. No issues were framed, and nothing prevented the respondent, then the appellant herein, to request the arbitral tribunal to recast the issues. If they were so vehement and so insistent on that these pleas also ought to have been considered and that the learned arbitrator has ignored these pleas, then nothing prevented them from requesting the learned arbitrator to recast these issues.
According to you, this settlement agreement remained
Unchallenged.
and source of undisputed obligations between the parties before the arbitration.
That is the finding of the learned arbitrator.
Source of undisputed obligation.
That is right.
That is what, very specifically I am using.
That is right. That has been my specific plea, and that is a specific finding of the learned arbitrator, that you have not challenged or questioned the settlement agreement in any manner. You may dispute the obligation thereunder, but the execution of the agreement, the entering into the agreement is not questioned by them. No declaration is sought, no counterclaim is filed. The learned arbitrator says, I am a creature of the contract. This is the contract. You are not questioning the contract. What do? I will allow the claims under the contract. I contended that.
It was your invocation of the.
That's right. I invoked.
And you gave up that part. You really resiled from in a way.
Which is what I'm submitting. I did not. It is their contention to pursue at this honorable court that I did. I did not. I have not resiled. I have not given up. In fact, my lord, to answer that there is a very straightforward answer to this proposition.
If you resile from, if they are right, then they are also entitled to back out.
Correct. Absolutely. Absolutely. If I have resiled, then they are also entitled to resile. Absolutely right. That is what they are seeking to urge now for the first time before this honorable court. Firstly, whether such a plea can be even heard. That is the first hurdle that the appellant needs to cross. Whether such a plea never raised before the learned arbitrator, never raised before the Section 34 court, that too in an arbitration jurisdiction, can it be urged for the first time before a Section 37 court? That is the first hurdle. Second, assuming that the argument can be heard, is there any merit in that argument? The answer to that is Section 21 of the Specific Relief Act. If, my lord, the Specific Relief Act can be seen, what did I seek before the learned arbitrator? In volume 1, my statement of claim, the reliefs that I seek, my lord, are set out. Volume 1, my statement of claim. At page 320 in the paper book. My lord has it. Prayer A, directing the respondent to pay the claimant a sum of rupees 4 crores with interest thereon at the rate of 18% is specific performance of their obligation, clause 7 of the settlement agreement. Prayer B, directing the respondent to pay the claimant a sum of rupees 23 crores together with interest thereon at the rate of so and so is specific performance of their obligation under clause 1. So prayer A and B are specific performance prayers seeking specific performance of this settlement agreement. Now prayer C, directing the respondent to pay the claimant a sum of rupees 14 crores by way of damages, not due under the invoices prior to the settlement agreement. If, my lord, my prayer A was simple, direct the respondent to pay 37 crores. They have committed fraud. They have diverted the amount from the escrow account. Therefore, the settlement is gone. Now you ask them to pay me 37 crores. That would be a clear case where I have given up on the settlement agreement and I'm making a claim now on the original invoices. I have provided services. I have raised invoices. They were supposed to pay me 37 crores. There were disputes and differences between us. Therefore, we arrived at a settlement agreement where they persuaded me saying, agree to 23, I'll pay you 23. So that is why I agreed to come down to 23. I come before the tribunal and say they have agreed to pay me 23, direct them to pay me 23. Then what is prayer C? Well, prayer C is covered by Section 21 of the specific relief. Power to award compensation in certain cases. In a suit for specific performance, which is what is the nature of the list before the learned arbitrator. In a suit for specific performance of a contract, the plaintiff may also claim compensation for its breach in addition to such performance. So I seek specific performance and I also seek damages. While doing so, it cannot be construed that I have given up the contract itself.
This amount 14 crores.
14 crores.
Exact
Yes.
invoice.
Yes.
It is that represent what?
Exact amount 26
I'll-
crores.
I'll-
plus this is
I'll
the
explain.
exact amount of the invoice.
Settlement.
Yes, no. It is the total value of the
Total
invoice.
amount.
Yes.
My lord may see the total original claim that I had
26 plus this.
is
amount
37.6.
Is exact 26, 23 plus
23.
14 is exact amount of the invoices.
Correct. That's what it is.
It can't
But
be-
I am not claiming it as due under the invoices. The nature of my claim is important. The amounts may coincidentally be the same. What is the nature of the relief that I seek? The nature of relief that I seek is not that this amount of 37.60 crores, which was my original claim against the appellant, due under invoices as consideration for the services rendered, is not the claim that I raised before the learned arbitrator. If my claim were for payment of money for services rendered, then I'm deemed to have given up the settlement agreement.
Let us see the award now. What is the award?
My lord, the award I'll take my lord through. Quickly, my lord, just take my lord through volume 2, just some of the relevant correspondences. To see, my lord, how the pleas initially were raised and what was the initial responses of the appellant, because the conduct matters. Volume 2, my lord. It begins at page 356, the settlement agreement. At page 359, clause 1, SOS agrees to pay INR 23 crores as full and final settlement, which will include receivables from projects. This money will be called as final settlement money. SOS agrees to pay the amount of INR 23 crores as mentioned below, as and when the same is received from NILE. That is the first obligation. The second, both parties agree to bear liability arising out of penalties or other deductions as may be levied by NILE in the proportion of 60% to emphasis and 40% to SOS. Well, I pause here for a minute. Much has been said about this being a conditional obligation. That 23 crores is subject to the condition that if penalties are imposed, penalties have to be shared. A plain reading of the settlement agreement does not say so. That is now the interpretation sought to be brought into play by the appellant, that it is conditional. The plain reading does not say so. You have to pay me 23 crores. If there is any penalty imposed, we will share those penalties. One is not conditional upon the other. Thereafter, my lord, 2 pages later at page 361, the arbitration clause. At page 361, the arbitration clause, and at page 362, clause 9, my lord, superseding agreement. 362, clause 9. All earlier claims that I had or they had against me stand superseded by this agreement. The learned arbitrator takes note of this clause also, my lord. That this settlement agreement encompasses all the earlier agreements, MOUs of the parties, and supersedes all previous negotiations, understandings, and agreements between the parties, whether in oral or written form. Pursuant to this agreement, my lord, at page 364, Exhibit P2, both parties agree to open an escrow account. I have prepared a synopsis, my lord. These dates and all will be available as well as cross-references to the exhibits. I'm just taking, my lord, through how all this transpired. Exhibit P2, both parties entered into an agreement to open an escrow account. Exhibit P3 at page 372. Exhibit P3 at page 372. On 25th August 2016, the appellant writes to NILE, to the government department, saying that, look here, we have opened an escrow account. Please remit all the monies due to us into this account only. They write to the government department. Exhibit P3. All these are undisputed. Because of their conduct, I was supposed to release 4 crores to them. I was supposed to pay. That is the clause in the settlement agreement, my lord. The clause here, that clause, my lord, will see. Clause 7 at page 360. In the settlement agreement, clause 7 at page 360. Subject to the escrow account being opened, emphasis shall pay, that is the claimant, shall pay an amount of 4 crores to SOS within 10 days of opening the escrow account for settling vendor payments as mentioned above. Both parties would work diligently to open the escrow account by completing the documentation required by each party. So this is to show my bona fide conduct in performance of my obligation under clause 7 of the settlement agreement. Upon the opening of the escrow account, I sincerely transfer 4 crores to them. That is at Exhibit P4, page 373. Then, my lord, for quite some time, I do not hear either from the appellant or from the government department. So at page 374 on 15th December 2017, a year later, at page 374, I write to the government department saying, look here, we had entered into this escrow agreement and we have written a letter to you that you have to remit the amounts into the escrow account. There is no response. I have no privity of contract with the government department, so there is no response to my letter at 374. Therefore, my lord, at page 378, Exhibit P8, I issue notice for arbitration. I get suspicious that something is afoot. And so I issue a notice for arbitration. Exhibit P8 at page 378, 25th January 2018. Their response, my lord, and this is where the responses to the pleas will begin, to see how what their stand was originally and what their stand is now before this honorable court. At page 382 is their reply to the notice for arbitration. What are the objections that they raised to my claim? I asked this. At page 382, Exhibit P9. At page 383, para 3, your client has made false claims only with a view to bypass the alternative remedy of negotiation provided in the arbitration clause before initiation of arbitration proceedings and solely for the purpose of seeking an interim order by misleading the court. The notice issued without exhausting alternative remedy being premature, our client refuses to agree to your request for reference to arbitration as the same is premature. All other allegations which are not specifically traversed to are not admitted and your client is put to the strict proof of the same. This is the only defense raised by them. What are you talking about? 23 crores is not even payable to you. Penalty has been imposed. We have to share the penalty. The obligation is conditional. You have given up the settlement agreement. Nothing like that is raised. All that they say is your arbitration invocation is premature. Nothing else is contended here in reply to the notice for arbitration. Since we are unable to agree on the constitution of the arbitral tribunal, I initiate proceedings under section 11 before this honorable court. An order comes to be passed in March 2019, my lord. That is Exhibit P13, P13 at page 391. Lord, just before that, at page 385, that government department informs me that the amount has been released directly to them. At page 385. What they have done, my lord, is while this correspondence is going on, they have instructed the government department not to remit the money into the escrow account and to direct it to some other account. That is the fraud played by them. At page 385, Exhibit P10. At page 386, my lord, the second paragraph, page 386, the second paragraph. Strategic Outsourcing Services Private Limited, my lord, 386.
Yes.
Strategic Outsourcing Services Private Limited, vide letter dated so-and-so, had requested for update of its bank account of so-and-so bank, and subsequently, vide their letter dated so-and-so, provided the details of new bank account and requested to update their bank account of Indus into Kotak Mahindra for the NPR project so-and-so. This is where they committed breach. They had agreed that the escrow account will be there. They, behind my back, have written to the government department, don't put it in the escrow account, put it somewhere else. And in my reply to the notice for arbitration, they simply say, no, your arbitration invocation is premature. No other defense raised. When I come before the this honorable court under section 11, they raise again only that contention. The section 11 order, my lord, is at page 391. It was marked as exhibit P13. My lord, their contention is considered at page 395, para 6 of the section 11 order. This was again the only objection. My lord, I will read from page 394. Page 394, the bottom 4 lines, my lord. It is further pointed out that the aforesaid averment of fact has not been specifically denied in the reply dated so-and-so sent by the respondent. And in the reply, it is stated that the petitioner has bypassed the remedy of negotiation. In any case, the aforesaid requirement is directory in nature. In support of aforesaid submission, reliance has been placed on the decision of the Supreme Court in so-and-so, so-and-so, so-and-so. On the other hand, the learned counsel for the respondent submitted that the petition filed by the petitioner is premature, as the petitioner has failed to avail of the remedy of negotiation as provided in the arbitration clause. It is also submitted that a complaint has been filed by the petitioner against the respondent alleging fraud. And since the issue relating to fraud cannot be gone into in arbitration proceedings, therefore the respondent has filed a civil suit against the petitioner seeking damages on account of breach of contract. It is further submitted that notice was issued seeking invocation of the arbitration clause prior to filing of the proceedings under section 9 of the Act, and the petitioner has also filed an insolvency proceeding. Therefore, instant petition is not maintainable in the absence of any arbitrable dispute. Premature and fraud. These were the contentions raised by them before the section 11 court, that invocation of arbitration is premature and the claim involves a question of fraud, which I have admittedly raised only in the police complaint, not before the learned arbitrator. At page 397, para 9, the section 11 code deals with both those contentions. At page 397, para 9, the provisions of the Act were amended by Act so-and-so of 2016, which came into force with effect from 2015. Subsection 6A was added to section 11 of the Act, which provides that the Supreme Court, or as a case may be the High Court, while considering an application under subsection 4 or subsection 5 or subsection 6, shall, notwithstanding any judgment, decree, or order of any court, confine to the examination of existence of an arbitration agreement. Admittedly, in the instant case, the agreement dated so-and-so executed between the parties contains an arbitration clause. The respondent can raise all his objections before the arbitrator under section 16 of the Act, which need not be examined in the summary proceedings. So far as submission of the respondent that this petition is premature is concerned, suffice it to say that in the notice dated so-and-so, the petitioner has clearly stated that the petitioner has been following up with the respondent to perform its obligations under the agreement. However, despite lapse of 60 days, no action was taken, and therefore the petitioner is forced to invoke the arbitration clause. In the reply dated 12/2/2018, the aforesaid averment of fact has not been specifically denied, and it has been merely stated that notice has been issued without exhausting alternative remedy. Besides that, Delhi High Court in the case of so-and-so Supra has held that even if the requirement as stated for invoking the arbitration is not complied with, the same cannot prevent reference to arbitration because the procedure or precondition has to be taken as directory and not a mandatory requirement. I am in respectful agreement with the aforesaid view. Therefore, the objection raised by the respondent that this proceeding is premature cannot be sustained. This is the finding of the learned arbitrator. But while immediately after this, I had filed a police complaint at page 437. Exhibit R13. This is where I say the diversion of the funds from the escrow account into another account is fraudulent act on their part. R13 at page 437. Lord, at page 439, para Q and para R, which forms the basis for their plea that the arbitration proceedings involve fraud. Page 439, para Q and R. From the foregoing, it is amply clear, Q and R. From the foregoing, it is amply clear that right from the inception of the transactions with Emphasis, the directors had intended to cheat Emphasis and they had accordingly conspired to dishonestly misappropriate Emphasis money. In furtherance of such criminal intent, the directors fraudulently and dishonestly induced Emphasis to provide a concession in the amounts due and also induce Emphasis to advance a sum of rupees 4 crores to SOSPL. SOSPL and its directors diverted the payments released by NILET from the escrow account to SOSPL's account and thereby dishonestly misappropriated the money that was to be paid to Emphasis by SOSPL as per the agreement and thus cheated Emphasis of 41 crores, etc. by their illegal actions. This is where I say fraud. I do not say fraud before the learned arbitrator. On the basis of my complaint, my lord, at page 440, an FIR is also registered against them. This is what transpired until the arbitration proceedings commenced. So my lords will see that in the initial responses, these were not the defenses raised at penalty, conditional payment, you have given up the settlement agreement, were not even there. This is ingenuity of lawyers subsequently. In the beginning, it was only, no, your arbitration agreement is invoked prematurely and that you have claimed fraud. Fraud is inarbitrable, which of course now is a diluted position, even fraud is arbitrable. On these contentions, my lord, in fact, again before the learned arbitrator, a section 16 application comes to be filed where these are the two specific contentions raised by them. The learned arbitrator has first, before the main award, has passed a preliminary award. That preliminary award dealt with these two contentions. And then in the main award, no other contentions were raised. Therefore, the learned arbitrator said, your settlement agreement is not disputed. Your obligation is not disputed. Emphasis is asking for 23 crores. 23 crores is not available for distribution. 17 is. 17 will be distributed 60-40 and the learned arbitrator allows my claim to that extent. That is all that is considered before the learned arbitrator. No other pleas were raised. No other issues were framed. These are the only issues. The only defenses raised by them, which the learned arbitrator has dealt with in a preliminary award, is premature invocation of arbitration and claim tainted by fraud, which is not arbitrable. That, my lord, was dealt with by the learned arbitrator in a preliminary award, volume 1. Now I'll come to the awards. Award and the section 34 code. Lord, this part, my lord, would want me to just continue tomorrow. I'll finish it tomorrow, half an hour. Tomorrow I'll continue. The award, the preliminary award, the main award, and the section 34. Just a few paragraphs, just to show.
The award 125.
Pardon, madam? Award at 120. No, before we come to the award at 120, that is a final award. Before that, my lord, at page 91 is the preliminary award. Under section 16, they first raised these defenses, which were the defenses in reply to my notice for arbitration and the defenses contended by them before the section 11 court. There are two awards, madam. One is at page 91 and the other begins at 97. 91 is the preliminary award in respect of their application under section 16. 97 is the main award on the statement of claim.
91 only says that
91 says premature is not a ground and fraud, you have raised it there before the complaint. There you continue, but the
secondary objections are overruled.
That's it. That's it.
Now at 125.
125, the distribution of funds, my lord, in accordance with, precisely in accordance with the settlement agreement. What was agreed in the settlement agreement that whatever comes from the government department.
That figure doesn't come here.
It does, my lord. This is what the amounts are. I'll take, my lord.
No, the
through-
10 crores, 69, 59, 630, what amount?
is the 17 crores. Look, initially when 4 crores came, 4 crores paid to me. That I received from.
According to you, the arbitrator has passed the award equivalent to the settlement award.
That's right.
So where is that figure?
Well, let the figure comes. What came to be released is 17 crores, which is what can be seen from the amount mentioned by them. 1 second. I'll take my lord to the relevant paragraph. I'll show my.
A total of 1, 2 and
No, the total of 1, no, total of 2 and 4
2 and 4.
is 17,
17.
which is what the amount received by them from the government department. 4 had already come to me and 4 is no longer an issue. Even they have considered that. 4 was earlier. 4 came to me. I have received the 4 because it came into the escrow account before they could change the account. They changed the account. Before they could change the account, 4 had come into the escrow account. I took that pursuant to an order of the Section 9 code. But thereafter, by then the account had been changed. They received the amount. What was the amount received by them is 17. That the learned arbitrator says 17 has been received. 60% goes to emphasis, 40% goes to you. So it is precisely and exactly in terms of the settlement agreement. Not 1 naya paisa more, not 1 naya paisa less. There can be no fault found by what the learned arbitrator has done. That is what the Section 34 court also says.
Those for the president vote amount, 6 crores.
Well, 6 crores is a 40% of the 17. 17 crores came, 17, 53, 43, 656. My lord has 125 at page 124 only. The amount is, the figure is mentioned, third line, 17, 53, 43, 656. That is the amount that came. That is 60-40. 60-40 is prior to relief 2 and relief 4. Undisputed, my lord. That is just simple arithmetic. 23 never came. I, in fact, contended before the arbitrator that since the settlement agreement is 23, whether they get 17, whether they get 20 or 11,
So arbitrator has given go by to settlement award?
no.
No.
No, he has not. He has given the settlement agreement effect to the settlement agreement. He has not given the go because the arbitrator cannot distribute what is not available. What came is 17. He said this is the amount available. Well, I'll take my lord tomorrow. I'll take my lord through the reasoning of the learned arbitrator. That will make it clear how these amounts have been available. I'll finish tomorrow, my lord. Half an hour if my lord gives me to. No, 23. My lord is saying that 23 has not been distributed, 17 has been distributed. Therefore, settlement agreement has been given the go by. The learned arbitrator gives an explanation for that also. He says 23 is what you expected. 23 has not come because what the clause 3 says, clause 2, clause 1 says specifically, they agree to pay me 23, subject to whatever comes from the government department. So the learned arbitrators, and I go to the arbitrator and say, see, they promised to pay me 23, ask them to pay me 23. The learned arbitrator says, subject to what comes from the government department. No. What has come from the government department? 1753. So I will distribute 1753 according to 60-40. That is the interpretation given by the learned arbitrator. Tomorrow, my lord, only the award and section 34 and I'll close.
Any method, 230 meters. Any other method?
Great.
Number 148, Ramesh KR.
That's, the Tashildar is present before the Honorable Court and remedial action has been taken, my lords. So far as the Tashindar's work, my lords, he has done 1 to 5 and submitted to the ADLR to do next 6 to 5. So far, Podi is concerned, my lords, it's partly done by the Tashildar and partly done by the ADLR. Lordship may grant some time, ADLR will complete the process, my lords, within a period of 10 weeks. The proposal has been sent to the ADLR.
Grant time. After this, pursuant to order dated 15/12/24, as stated by learned Petitioner on the education Tehsildar, Telangana Taluka, so and so on.
Yes.
Only present in the plans of the directions of that present of
Please, my lord, 1.
15/12/24, which amounts to part compliance of direction. Then is taken in court. Full stop. So stated by learned additional that the remedial action has been taken. The rest of the exercise is to be done by
Lords, 10 weeks time maybe, but the ADLR minutes.
what will you do?
Lords, he has to fix the boundary, my lords, it is called 6 to 10.
My lord, learned single judge of this honorable court directed to do it within 2 months. Now, my lord, at least within another 2 weeks, my lord. February.
Trying to close the contempt by directing that the rest of the exercise will be completed within a period of 8 weeks.
Right.
Closed off. This court is not gone into any aspect of merits. Not a contempt jurisdiction except soliciting compliance.
Obliged.
In the event of not doing it, my lord, I may be put in liberty, my lord, since the contempt proceedings. Please.
That's the presence of the Tashildar may be
Noted.
dispensed also.
Give the name. Sir is over. There is a question of this.
Obliged.
To give the name of.
Okay.
Much.
My lord, just one mention with regard to the next case. The compliance has been done and there are previous orders of this honorable court that has dropped the contempt, similar contempt proceedings. So I would like to just, the compliance report is already there. I'd like to place the decisions of this honorable court, which is similarly situated. This is the next matter, 149, my lord, contempt.
No, the other side will not be there.
Venkatesh CR.
Can keep it there.
Please, my lord, please.
That's
Lordship, seal number 151, 230 matter.
110.
Interim order is there, it's going to be extended. Seal number 140.
Interim order will be extended wherever it is open.
108, this is regarding microchipping of dogs. If the matter can be taken up in the first week of January.
What is it about?
This is about microchipping of dogs, the PI, public interest litigation. First week of January, my lords, on 10th or something. Sometime, because every day the project is being carried out, which is not, it's illegal. The tender process itself is illegal, against the law. 13th day before, 11th January or something. Uh, 15th. Or 20th.
Your lord, 151, your lordship. It can be disposed of, your lordship. 151, seal number.
Compliance affidavit has
I will
been filed.
challenge the liberty to challenge annexure R4, your lordship. 151, 230.
Complied with?
Yes, they are complied. I may permit to liberty to challenge annexure R4.
Present petition does not survey. This disposal, the request of learned, the tenant is observed that if the complainant is
Obliged.
for the endorsement, it is open for him to challenge the same on merit.
Annexure R4, your lordship. Endorsement is annexure R4.
Create independent. With this court does not express anything on merit.
Serial number 98, my lords. Serial number 98, it's a PIL pertains to compulsory imposition of Kannada language on students of CBSE and ICC school. I had mentioned this matter previously. I filed an IA for early hearing, it's been allowed. My only request is a date be fixed and time be fixed for hearing. It's been pending for about 8 months now. It's not reaching, lords. The students are suffering. The
Date is in our hand, time is in your hand.
my lords,
Fixing of date is in our hand,
please, my lords.
of time is in your hand.
My lords, time also be fixed 2:30 PM, my lords, because students are suffering. The learning of language is becoming difficult and their academics is
Take up
suffering.
once he based it on it.
My lord, seen,
First week of, first or second.
My lord, serial number 134.
Wait for me.
There is an office objection, annexure Q, wherein annexure Q is only a document furnished for reference of annexure A and B. It is a supporting document. Therefore, I request that objection be handled as
This is regarding.
Office.
is dispensed.
My lord.
Lords, item 99, my lords. Item 99, my lords.
date that I will fix for.
Date will be given. Give all dates, all matters will be given there.
My lords, item 99.
All matter in the board will be without date.
My lords, item 99, my lords, your lordship. My lords, may I make a mention through VC?
Yes.
Serial number 154, my lord. Today I filed wakalat for respond number 1. But the impugned order of the learned single judge is already given effect by the appellant. Therefore, my lord, the appeal may not survive for consideration. My lord. I have even informed the appellant counsel also. The matter was taken on Friday
You are correspondent.
for respond number 1, my lords.
Where is appellant?
Not the appellant, I have informed, my lords, because the Friday lords directed to advise the.
List it tomorrow.
Please.
Yes, my lord. Serial number
serial
130,
number 101. I request your lordships to kindly have it immediately after vacation.
Which one?
In your serial number 101.
Yes, my lord.
Immediately.
Serial number
99, my lords, I'm sorry.
Yes.
My lord, this is a matter your lordship kindly recollect. A cow slaughter house has been set up within 10 kilometers of radius. My lord, the service is completed, my lords. Any date this month, my lords, your lordships can kindly consider. Service is item 99, my lords. Your lordships pass a detailed order. within the Kalaburgi airport limits, my lords, within 10 kilometers.
My lords, I appear for respondent number 13 in serial number 99. My lords, I filed my wakalat on Friday. My lords, I require some time to file statement of objections to the petition. Any
Lords,
date in January, my lords, I'll file my statement of objections and it can be heard.
Serial number, my lords, kindly, my lords.
My lords, any.
Serial number 80, my lords. My land is acquired in the year 2014, my lords. Single will be directed to pay the compensation, my lords. They have not complied there.
83, my lord.
My lords,
83,
my
my
lords,
lord. I'm
kindly,
retiring this month, my lord. I'm retiring by end of this month, my lord.
my lords.